Brackett, Buckner-Webb, Cameron, Davis, Durst, Fulcher, Getty, Guthrie, Hagedorn, Hyder, Hill, Johnson, Keogh, Lacey, Blakey, Lodge, Martin, McKenzie, Mortimer, Nonini, Nuxel, Patrick, Pierce, Rice, Schmidt, Sidaway, Stennett, Thane, Tippett, Fick, Work, Winder, Brackett, Hill, Martin, Pierce, Fick,
Roll call shows 33 present, 2 absent, excused. Quorum being present, Senate is in order. Senate will advance second order of business. Prayer by Chaplain James Weberding and Pledge of Allegiance. We'd ask our friends in the gallery to rise and join us in prayer.
Let us pray. Oh, infinite, infinite God, our senators, our Senate staff, our Senate President are on the final stretch of this legislative session. The early sprinting through committees and through bill formulation and the like has given way to what can best be described as an endurance race. Although we have an exceptional team, they are human and they have limited resources. You, who are infinite in wisdom, in genius, in strength, and in passion, I pray that you will resupply their resources for the business of today. Thank you in Jesus' name. Amen.
Amen. Now be led, Pledge of Allegiance, by our page, Carson Cole. Carson.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Senate will advance third order of business, reading corrections to journal.
March 21st, 2013. The Judiciary and Rules Committee reports that the Senate Journal of the proceedings of March 20th, 2013 was read and approved as corrected. Lodge Chairman.
The report will be filed in the office of the Secretary. Senator Davis.
Mr. President, Senators, or Mr. President, may I have a personal privilege?
You have the floor, Senator.
Mr. President, Senators, it is not our intent to go into the 10th order of business today, so if you have either the concurrent resolution or the joint memorial, you will have a reprieve for the day. We do have some administrative work, however, between here and the 13th order of business, and we'll get ourselves to the third reading calendar as quickly as possible. Thank you. Mr. President, I ask unanimous consent Senate advance to the 6th order of business.
Prior to advancing, Senator Vick will be recorded present at this order of business. The Senate will advance the 6th order of business. Reports to Standing Committee. Senate's at the 6th order of business.
March 21st, 2013. The Judiciary and Rules Committee reports that Senate Bill 1184, 1187, 1188, 1189, Senate Resolution 101, Senate Concurrent Resolutions 129 and 130 have been correctly printed. Lodge Chairman.
Senate Bill 1184 will be referred to the State Affairs Committee. Senate Bills 1187 and 1188 will be referred to the Finance Committee. Senate Bill 1189 will be referred to the Judiciary and Rules Committee. Senate Concurrent Resolution, or Senate Resolution 101, Senate Concurrent Resolutions 129 and 130 will all be referred to the 10th order of business and held for one legislative day.
March 21st, 2013. The Judiciary and Rules Committee reports that the Senate amendments to Senate Bill 1118, House Bills 206, 221, Senate Bills 1147, 1148, and Senate Bill 1166 have been correctly printed. Lodge Chairman.
Report will be filed in the Office of Secretary.
March 21st, 2013, the Judiciary and Rules Committee reports that Senate Bill 1118 as amended, 1147 as amended, 1148 as amended, and Senate Bill 1166 as amended have been correctly engrossed. Lodge Chairman.
Senate Bills 1118 is amended, Senate Bill 1147 is amended, Senate Bill 1148 is amended, Senate Bill 1166 is amended. Refer to the 11th order of business for first reading.
March 21st, 2013, the Judiciary and Rules Committee reports that enrolled Senate Bill 1025, 1057 is amended, 1091 is amended, 1098, 1048 is amended, 1034, 1035, 1128, 1129, 1130, 1131, 1132, 1139, 1140, 1143, 1144, 1063, 1100, 1033 is amended, 1061, 1062 is amended, 1142, 1006 is amended, and Senate Bill 1064 were delivered to the Office of the Governor at 8:30 a.m. March 21st, 2013.
Report will
Lodge
be
Chairman.
filed in the office of Secretary.
March 20th, 2013, the Local Government and Taxation Committee reports out House Bill 243 and recommend that it do pass. Sit away, Chairman.
House Bill 243 will refer to the 12th order of business, second reading.
March 21st, 2013, the Education Committee reports out House Bill 226 and House Bill 260 and recommend that they do pass. Getty, Chairman.
House Bills 226 and 260 will refer to the 12th order of business, second reading.
There is no further business in the sixth order, Mr. President.
Davis.
Mr. President, I ask unanimous consent. Send it advance to the 9th order of business.
Without objection, send advance to 9th order of business. Senate's at the 9th order of business.
March 20th, 2013. Mr. President, I transmit herewith House Bill 286, 274, 292, and House Bill 279, which have passed the House. Alexander, Chief Clerk.
House Bills 286, 274, 292, and 279 will be for the 11th order of business.
There is no further business in the ninth order, Mr. President.
Mr. President, ask unanimous consent. Send advance to the 11th order of
Objection,
business.
send advance to the 11th order of business. First reading of bills. Senate's at the 11th order of business.
Mr. President, I ask unanimous consent that all bills on first reading be read by number, author, and title only, and the journal show they've been read at length.
Hearing no objection, so ordered.
In the Senate, Senate Bill number 1190 by Finance Committee, an act appropriating monies to the Department of Health and Welfare for the Medical Assistance Services Division for fiscal year 2014.
Senate Bill 1190 will be referred to the Judiciary and Rules Committee for printing.
In the House of Representatives, House Bill number 206, as amended in the Senate by Education Committee, an act relating to public charter schools to revise provisions relating to state support of special programs. In the House of Representatives, House Bill number 221, as amended in the Senate by Education Committee, an act relating to education to provide for an exception to make technical corrections.
House Bill 226 is amended in the Senate, and Senate Bill 221 is amended in the Senate. Refer to the 12th order of business, second reading. They call them Senate bills. Both of these are House bills. House Bill 206 is amended in the Senate, and House Bill 221 is amended in the Senate. We'll refer to the 12th order of business.
In the Senate, Senate Bill number 1118 as amended by State Affairs Committee, an act relating to financial interest in a dealer or wholesaler of beer. In the Senate, Senate Bill number 1147 as amended by State Affairs Committee, an act relating to education to remove language relating to fact finders, appointment and hearings, to establish provisions relating to terms of agreements. In the Senate, Senate Bill number 1148 as amended by State Affairs Committee, an act relating to education to remove language relating to a notice concerning renewal of a contract. In the Senate, Senate Bill number 1166 as amended by State Affairs Committee, an act relating to domestic cervidae to provide for the submission of brain tissue from certain domestic cervidae to official laboratories for the purpose of testing for chronic wasting disease.
Senate Bills 1118 is amended, 1147 is amended, 1148 is amended, and 1166 is amended. Refer to the 12th order of business, second reading. Senator Brackett will be recognized present at this order of business.
In the House of Representatives, House Bill number 286 by Revenue and Taxation Committee, an act relating to education to establish provisions relating to a tax credit for contributions made to a scholarship granting organization. In the House of Representatives, House Bill number 274 by State Affairs Committee, an act relating to the Traffic Safety Education Program. In the House of Representatives, House Bill number 292 by Health and Welfare Committee, an act relating to assault and battery, to provide that any person who commits assault or battery upon certain persons shall be subject to a certain punishment. In the House of Representatives, House Bill Number 279 by State Affairs Committee, an act relating to registrations, to revise registration provisions relating to certain vehicles, and to provide for the registration of certain non-resident vehicles pursuant to specified law.
House Bill 286 will be referred to the Local Government Taxation Committee. House Bill 274 and 292 will be referred to the Judiciary and Rules Committee, and House Bill 279 will be referred to the Transportation Committee.
There is no further business in the 11th order, Mr. President.
Senate advances the 12th order of business. Senate's at the 12th order of business. Senator Davis.
Mr. President, I ask unanimous consent that all bills in the 12th order of business be read by number and author only, and the general show they've been read at length.
Without objection, so ordered.
In the House of Representatives, House Bill Number 261 by Education Committee. In the Senate, Senate Bill Number 1149 by State Affairs Committee. In the Senate, Senate Bill Number 1150 by State Affairs Committee. In the House of Representatives, House Bill Number 138 by Local Government Committee. In the House of Representatives, House Bill Number 242 by Revenue and Taxation Committee. In the House of Representatives, House Bill Number 303 by Appropriations Committee. In the House of Representatives, House Bill Number 304 by Appropriations Committee. In the House of Representatives, House Bill Number 305 by Appropriations Committee. In the House of Representatives, House Bill Number 306 by Appropriations Committee. In the House of Representatives, House Bill Number 310 by Appropriations Committee. In the Senate, Senate Bill Number 1186 by Finance Committee. In the House of Representatives, House Bill Number 124 by Judiciary, Rules, and Administration Committee.
House Bill 261, Senate Bill 1149 and 1150, House Bills 138, 242, 303, 304, 305, 306, 310, Senate Bill 1186, and House Bill 124 will all be referred to the 13th order of business, third reading calendar.
There is no further business in the 12th order, Mr. President.
To the 13th order of business, third
Mr.
reading.
President.
Senator Davis.
Mr. President, I ask unanimous consent. Senator Goody Subculture.
Without objection, Senator Beatties.
Mr. President, while we're at ease, and senators, we have a group today up in the gallery from Bora High School that is visiting, and I'd ask you to make them welcome. I hope you have a great time at the Capitol today.
Mr. President, good senators, today we have with us from Filer Elementary School, Susan Hamby, Stacy Beam, and Andrea Tickner. If you'd stand, please. And these good teachers from Filer Elementary would ask that we give thoughtful consideration to the education bills. So please help me welcome them.
Senate will come to order. Senate's 13th order of business and has for final consideration House Bill 248. Secretary will read the bill.
In the House of Representatives, House Bill Number 248 by Health and Welfare Committee, an act relating to health insurance exchange, to provide a short
Mr.
title.
President.
Senator Tippett.
Mr. President, I ask unanimous consent that further reading of House Bill 248 be dispensed with, and the journal show it's been read the third time at length, section by section, placed before the Senate for final consideration.
Hearing no objections,
Mr. President, I object.
Secretary will read the bill.
An act relating to health insurance exchange. Amending Title 41 Idaho Code by the addition of a new Chapter 61 Title 41 Idaho Code to provide a short title to state legislative purpose and intent, to define terms, to establish the exchange and the board, to provide for powers and the authority of the exchange, to provide for reporting, to authorize reliance by the exchange on other agencies, to provide that the exchange shall not preempt the duties of the Department of Insurance, to provide for the preference of Idaho contractors in a health insurance exchange, to provide for severability and declaring an emergency. Be it enacted by the Legislature of the State of Idaho, Section 1, that Title 41 Idaho Code be the same as hereby amended by the addition thereto of new chapter, to be known and designated as Chapter 61, Title 41 Idaho Code, and to read as follows: Chapter 61, Idaho Health Insurance Exchange Act. 41-6101, short title. This chapter shall be known and may be cited as the Idaho Health Insurance Exchange Act. 41-6102, Purpose and Intent. It is the public policy of the State of Idaho to actively resist federal actions that would limit or override state sovereignty under the 10th Amendment of the United States Constitution. Through this legislation, the State of Idaho asserts its sovereignty by refusing to surrender decision-making authority over health care issues, which are matters appropriately left to states and individual citizens. The purpose of this chapter is to establish a state-created, market-driven health insurance exchange that will facilitate the selection and purchase of individual and employer health benefit plans. The creation of a state-based health insurance exchange will provide an Idaho-specific solution that fits the unique needs of the state of Idaho. Participation in the exchange is voluntary in that no person or employer shall be required by this chapter to purchase a health benefit plan through the exchange. Creation of the exchange and its operation is deemed a public purpose intended to enhance Idaho residents' choice regarding options and access to health insurance. 41-6301, definitions. For the purpose of this chapter, 1. Board means those individuals who, acting as a board of directors of the exchange, govern and act for the exchange pursuant to Section 41-6104 Idaho Code. Number 2, conflict of interest means that by taking any action or making any decision or recommendation on a matter within the authority of the board, a member of the board or a person within the member's household or any entity with which the member or a person within the member's household is associated receive a pecuniary benefit or detriment unless the pecuniary benefit or detriment would apply to the same degree to a class consisting of all persons within the particular class in this state. 3, director means the director of the Department of Insurance of the state of Idaho. 4, exchange means the Idaho Health Insurance Exchange established pursuant to this chapter. 5, health carrier has the same meaning as carrier as set forth in Section 41-5203, number 5, Idaho Code. 6, person has the same meaning as set forth in Section 41-104, Idaho Code. 7, producer has the same meaning as set forth in Section 41-10038, Idaho Code. 41-6104. Establishment of the exchange and the board. 1. There is hereby created an independent body, corporate and politic, to be known as the Idaho Health Insurance Exchange. Said exchange may exercise the authority and powers conferred by this chapter, and such exercise shall be deemed and held to be the performance of an essential public function. 2. The exchange created by this chapter is not a state agency, shall not be subject to the purchasing statutes and rules of the state of Idaho or subdivisions of the state, including, but not limited to, Chapters 28 and 57, Title 67, Idaho Code, and shall operate subject to the supervision and control of its board. 3. The board shall consist of 19 total members with 17 voting members. Subject to the provisions of this section, members of the board shall collectively offer expertise, knowledge, and experience in health benefits administration, healthcare finance, health plan purchasing, healthcare delivery system administration, public health and health policy issues related to a small employer and individual markets, and the uninsured. A majority of the board shall not collectively represent health carriers and producers. The 14 voting members who are not members of the legislature shall be appointed to the board by and to serve at the pleasure of the governor. The members appointed to the board by the governor shall be subject to confirmation by the Senate, provided that upon appointment the board members shall have the full authority to exercise all the rights and duties and participate in all decisions required of that position. The 17 voting members of the board shall be appointed as follows. A. 3 members representing different health carriers appointed by the governor. B. 2 members representing producers appointed by the governor. C. 3 members representing individual consumer interests appointed by the governor. D. 4 members representing small employer business interests appointed by the governor with, at that time of appointment, Roman numeral 1, 1 member representing small employer business interests employing between 1 to 10 employees. Roman numeral 2, 1 member representing small employer business interests employing between 11 and 25 employees. Roman numeral 3, 1 member representing small employer businesses interest employing 26 or more employees. And Roman numeral 4, 1 at-large member. E, 2 members representing the healthcare providers appointed by the governor. F, 1 member of the House of Representatives appointed by the Speaker of the House. G, 1 member of the Senate appointed by the President pro tempore. And H, 1 member of the legislature representing the minority party in the legislature appointed by the minority leadership. The director or his designee and the director of the State Department of the Health and Welfare or the designee shall serve as ex officio non-voting member of the board. For the 14-member board appointed by the governor shall serve a term of 4 years or until a successor is appointed. A board member may be appointed by the governor to serve subsequent terms. A vacancy in the member's position on the board shall be filled in the same manner as the original appointment. 5. Whenever a member of the board has a conflict of interest on a matter that is before the board, the member shall fully disclose it to the board, abstain from any vote on the matter, and shall also comply with additional requirements established pursuant to the plan of operation under Section 41-6105 Idaho Code. 6. Neither members of the board nor any other person working or performing services for the exchange shall be A. considered public officials, employees, or agents of the state of Idaho by virtue of their service on the board or performance of services for the exchange, or B. eligible for or entitled to benefits from the Public Employee Retirement System of Idaho. 7. Nothing in this chapter shall prevent a member of the board who is otherwise a current or former state employee from receiving his usual state compensation and benefits while serving on the board. 8. All members of the board shall be held in accordance with the open meeting law as provided for in Chapter 23, Title 67 Idaho Code, shall be held in an open public forum, and every reasonable effort shall be made to make such meetings televised or streamed in video and audio format. 9. The board shall contract for annual audit for the exchange by independent third party and shall accept requests for proposal to bid on such contract. 10, the board shall develop, adopt, and implement procurement policies and guidelines. 11, premium rates charged by a health carrier for health benefit plan or standalone dental plan offered in exchange shall be based upon Idaho rating areas established by the director consistent with 42 U.S.C. Section 30 GG 41-6105, Powers and Authorities of the Exchange. Unless otherwise required by this chapter, in the discretion of the board, the exchange shall have the powers and authority to A, perform all duties that are necessary and appropriate to implement a health insurance exchange and provisions of this chapter. B, adopt bylaws for the regulation of its affairs and the conduct of its business subject to the review and approval by the director. The director's consent shall be required for any amendment to the bylaws. C, assess and collect fees from the participating health carriers, exchange users, and receive funds from any other source that shall be used solely for the purpose of this chapter. The exchange shall not be subject to income tax imposed by the state of Idaho under Chapter 30, Title 63, Idaho Code. D, appoint an advisory committee as deemed necessary by the board. E, taking legal action to recover any amounts lawfully owed to the exchange or otherwise consistent with this chapter. F, enter into contracts to effectuate and implement a health insurance exchange and shall accept requests for proposal to bid on such contracts. And G, develop, adopt, and implement a plan of operation and other governing documents to fulfill the requirements of this chapter. Number 2, the exchange powers and authorities shall be subject to the following limitations. A, the exchange shall not have the power to alter its own legal structure. B, the exchange shall be financially self-supporting and shall not request any financial support from the state and shall not have any power to tax or encumber state assets. C, the exchange shall be voluntary marketplace with the purpose of preserving individual choice and facilitating the informed selection and purchase of health benefit plans by eligible individuals, eligible employers, and eligible employees. Neither the exchange nor agency of the state of Idaho shall require any person to use or participate in the exchange, nor have the authority to impose upon or collect from person any penalty for failure or refusal to participate in the exchange or to purchase a health benefit plan or standalone dental plan. D, the exchange shall not prohibit a health carrier from participating in the exchange or prohibit a health benefit plan or standalone dental plan from being sold in exchange so as long as the health carrier health benefit plan or standalone dental plan meets all requirements of applicable law and any requirements of the exchange consistent with this chapter. E, the exchange shall not prohibit or preclude a health carrier from offering insurance or standalone dental plan outside the exchange. F, the exchange shall not prohibit a producer from participating in the exchange, and any producer participating in the exchange shall be entitled to payment for his service through written fee agreements with the individuals or small employers utilizing the services of said producer or through the commissions offered by health carriers participating in the exchange. G, before the exchange begins taking applications or collecting information from the exchange users, the board shall certify to the director and the governor that personal information collected from and about the person who voluntarily uses the exchange, including but not limited to healthcare records and income, it will continue to be secure. H, the exchange shall not inquire about the use, ownership, possession, or storage of any firearm or ammunition by anyone using the exchange. I, in the event of the Patient Protection and Affordable Care Act or any section thereof or rule enacted thereto is declared unconstitutional or otherwise invalid by the federal court, unless such ruling is stayed by the court, the exchange shall immediately cease to enforce those affected provisions by the PPAC or rules. J, the state of Idaho shall not be liable for any obligations of the exchange. And K, the board shall not be liable for any obligations of the exchange. No member of the board shall be liable, and no cause of action any nature may rise against them for any act or omission related to the performance of their powers and duties under this chapter. Unless such act or omission constitutes willful or wanton misconduct, the board may provide for indemnification or legal representation for its members. 41-6106 report. Number 1, the exchange shall submit a written report of its activities and the condition of the exchange to the director, the governor, and the director of the Legislative Service Office for distribution to all legislators on or before January 31st, 2014, and annually on or before each January 31st thereafter. The exchange shall also report to the appropriate Senate and House of Representatives and germane committees on any exchange to the bylaws or policies and any changes or updates from the Federal Department of Health and Human Services regarding essential health benefits or operation or conditions of the exchange on or before January 31st, 2014, and annually on or before January 31st thereafter. Number 2, for any changes by the board to the fee schedule charged to exchange users or participants, the exchange shall at the next legislative session report to the appropriate Senate and House of Representatives germane committees on or before January 31st. 41-6107, relation to other laws. The board and the exchange are entitled to rely upon work performed by the director and the director of Idaho Department of Health and Welfare in furtherance of the purpose of this chapter that are not otherwise inconsistent with their respective statutory duties and authority. Nothing in this chapter and no action taken by the exchange pursuant to this chapter shall be construed to preempt or supersede the authority of the director. To regulate the business of insurance within the state pursuant to Title 41 Idaho Code and administer and enforce rules adopted in accordance therewith. 41-6108, Idaho Contractors in the Health Insurance Exchange. Pursuant to Sections 41-6104 and 41-6105 Idaho Code, the board shall, to the fullest extent practicable, enter into contracts with businesses conducting business in Idaho, employing citizens to the state and to staff, and provide support for the exchange. 41-6109, severability. The provisions of this act are hereby declared to be severable, and if any provision of this act or the application of such provision to any person or circumstance is declared invalid for any reason, such declaration shall not affect the validity of the remaining portions of this act. Section 2, an emergency existing therefore, which emergency is hereby declared to exist, this act shall be in full force and effect on and after its passage and approval, provided, however, that should the Federal Department of Health and Human Services and or the United States Congress change both the establishment date and the eligibility limitation date for the exchange, the governor shall, upon his determination that such events have occurred, issue a proclamation declaring that Idaho will not be obligated to comply with the new dates as set by HHS or the United States Congress. The governor shall file such proclamation with the Secretary of State.
Thank you, Madam Secretary.
Thank you, Mr. President.
The Senate
you,
now,
Secretary.
The Senate now has for final consideration Senate Bill 248. Senator Tippett recognized to open debate.
Thank you, Mr. President, and I'd like to thank the Secretary as well for doing an excellent job of reading the bill for us today. Well, Senators, here we are again. The House took Senate Bill 1042 that passed this body, made some changes to it, created a new bill, passed it, and sent it back to us. Since we've already had a thorough discussion of that bill, I'll do a quick review, and maybe the review won't be as quick as you would like, but I feel that it's important that we go through the bill again, even though we've just heard it completely. And I'm going to, as I review the bill, emphasize the additions that the House has made to the bill. The purpose and intent section of the bill hasn't changed. I hear, however, various theories speculating on why Idaho lawmakers would want to create a state health insurance exchange. So let's be clear on this one point. Most of us don't want an exchange of any kind under the provisions of the Patient Protection and Affordable Care Act. That's why the intent language reads as it does, and I apologize. I realize we've just heard it, but it expresses so well how most of us feel, I think, that I'm going to read that section to you again. It says this: "It is the public policy of the state of Idaho to actively resist federal actions that would limit or override state sovereignty under the 10th Amendment of the United States Constitution. Through this legislation, the state of Idaho asserts its sovereignty by refusing to surrender decision-making authority over health care issues, which are matters appropriately left to states and individual citizens. The purpose of this chapter is to establish a state-created, market-driven health insurance exchange that will facilitate the selection and purchase of individual and employer health benefit plans. The creation of a state-based health insurance exchange will provide an Idaho-specific solution that fits the unique needs of the state of Idaho. Participation in the exchange is voluntary, in that no Idaho citizen or employer shall be required by this chapter to purchase a health benefit plan through the exchange. Creation of the exchange and its operation is deemed a public purpose intended to enhance Idaho residents' choice regarding options and access to health insurance." That is a statement of intent and purpose of the bill. And it makes it clear that the state of Idaho intends to actively resist federal actions that infringe on the rights granted to the states under the 10th Amendment of the United States Constitution. Now let's review the content of the bill. Section 416103 contains definitions that are used throughout the chapter. There are no changes to that section, so I'm not going to review those definitions with you. Section 416104, which begins on line 16 of page 2, creates the exchange and the board. The exchange is to be known as the Idaho Health Insurance Exchange and is established as an independent body, corporate and politic. This structure allows us to maintain appropriate control over the exchange while providing significant independence for the exchange. Further, it isolates the exchange and the state so that the state is not responsible for the liabilities of the exchange. The federal law allows for the exchange to be a nonprofit, but the state can't create a corporation, so a model was chosen that's similar to other quasi-state entities, as we've mentioned before, like the State Insurance Fund, the Idaho Housing and Finance Association, and the High Risk Pool. Subsection 3 describes the makeup of the board. The board will now consist of 19 total members. That's an addition of 3 members over the previous legislation. The additions are made on page 3, lines 9 through 14. It adds a member of the House of Representatives, a member of this body, a member of the Senate, and a member of the minority party. 17 of the 19 members are voting members: the Director of the Department of Health and Welfare and his or her designee, and the Director of the Department of Insurance or his or her designee are ex officio, non-voting members of the board. The makeup of the committee is otherwise unchanged in this legislation. You will recall from our previous discussions that board members are not employees of the state simply by virtue of their service on the board. Subsection 8 mandates that all meetings of the board shall be held in accordance with the open meeting law, and new language added to the end of line 39 on page 3 and including lines 40 and 41 state that the meeting shall be held in an open public forum, and every reasonable effort shall be made to make such meetings televised or streamed in video and audio format. Subsection 9 on lines 31 and 32 requires the board to contract for an annual audit by an independent third party. Subsection 10 states that the board will develop, adopt, and implement procurement policies and guidelines. Subsection 11, which begins on line 47 of page 3, is new. It requires that premium rates charged by a health carrier for a health benefit plan or standalone dental plan offered in the exchange shall be based upon Idaho rating areas established by the director. Section 416105, beginning on line 1 of page 4, enumerates the powers and authority of the exchange. These are the highlights that I think are important. Subsection 1B, to adopt bylaws. The bylaws will be subject to the review and approval of the Director of the Department of Insurance, and any changes to the bylaws will require the Director's consent. Subsection 1C, which begins on line 9 of page 3, gives the exchange the authority to assess and collect fees from participating health carriers, exchange users, or participants, and to receive funds from any other source that shall be used solely for the purpose of this chapter. The exchange is given the authority to appoint advisory committees as needed and to take legal action to recover any amounts lawfully owed to the exchange. Subsection F gives the board the authority to enter into contracts to effectuate and implement a health insurance exchange, and new language added to lines 18 and 19 requires the board to accept requests for proposal to bid on such contracts. Subsection G grants the board the authority to enter into contracts and to develop, adopt, and implement a plan of operation. There are also enumerated limitations placed on the power and authority of the exchange. The limitations are found in subsection 2, beginning on line 22 of page 4, and these limitations include the following. A, the exchange will not have the power to alter its own legal structure. B, the exchange must be financially self-supporting and shall not request any financial support from the state and shall not have the power to tax or encumber state assets. In subsection 2, C, the exchange is explicitly prohibited from requiring any person to use or participate in the exchange, nor does it have the authority to impose upon or collect from a person any penalty for failure to or refusal to participate in the exchange or to purchase a health benefit plan or standalone dental plan. Subsection 2D clearly states that any health benefit plan or standalone dental plan offered by any health carrier may be sold in the exchange as long as the plan meets all the requirements of applicable law and of the exchange. Subsection 2E prohibits the exchange from attempting to preclude any health carrier from offering insurance outside the exchange, and F deals with the issue of insurance agents or producers, as they are referred to here. Excuse me. It clearly states that any producer participating in the exchange shall be entitled to payment for his services through written plea agreements with the individuals or small employers utilizing the service of said producer, or through commissions offered by health carriers participating in the exchange. G, H, and I are all new subsections. G requires that before the exchange begins taking applications or collecting information, the board must certify that the information they collect is and will continue to be secure. H, again, which is also new, prohibits the exchange from inquiring about the use, ownership, possession, or storage of any firearm or ammunition by anyone using the exchange. I, again, also new, is a very important provision, I believe, and in my mind, it may be the best addition to the bill made by the body across the rotunda. I states this: in the event the Patient Protection and Affordable Care Act PPACA PL 111-148, it's a reference to the federal law, or any section thereof or rule enacted thereto, is declared unconstitutional or otherwise invalid by the federal court. Unless such ruling is stayed by the court, the exchange shall immediately cease to enforce those affected provisions of the Patient Protection Affordable Care Act or rules. Many are hopeful, excuse me, and I'm among them, that the courts will eventually strike down the Affordable Care Act. If that happens, we don't even have to take any action to get out of this mess. It's already done right here. The exchange will immediately cease to enforce the affected provisions of the Affordable Care Act or its rules. I like that. I think it's a great addition. J states that the state of Idaho shall not be liable for any obligations of the exchange, and K makes it clear that the board is not liable for obligations of the exchange. Further, it exempts board members from liability for any acts or omissions related to the performance of their powers and duties, unless those acts or omissions constitute willful or wanton misconduct. Section 416106, starting in the middle of page 5, requires the exchange to submit a written report of its activities and the condition of the exchange to the director, the governor, and the director of Legislative Services Office for distribution to all legislators on or before January 31st, 2014, and on or before January 31st in subsequent years. New language, beginning on line 26, excuse me again, requires the exchange to also report to the appropriate Senate and House of Representatives germane committees on any changes to its bylaws or policies and any changes or updates from the Federal Department of Health and Human Services regarding essential health benefits or operation or conditions of the exchange on or before January 31st, 2014, and annually on or before each January 31st thereafter. A new subsection 2, beginning on line 32, requires the exchange to report to the appropriate Senate and House of Representatives germane committees any changes by the board to the fee schedule charged to exchange users or participants. Section 416107, which is found towards the bottom of page 5, allows the exchange to rely upon work performed by the Director of the Department of Insurance and the Director of Health and Welfare, and makes it clear that no action taken by the exchange pursuant to this chapter shall be construed to preempt or supersede the authority of the Director to regulate the business of insurance within the state. There is a new section, 416108, found at the bottom of page 5. It requires the board to the fullest extent practicable, enter into contracts with businesses conducting business in Idaho and employing citizens of this state to staff and provide support for the exchange. The bill also makes an addition to Section 2. Starting on line 10, this new language is added. Provided, however, that should the Federal Department of Health and Human Services and/or the United States Congress change both the establishment date and the eligibility limitation date for the exchange, the governor shall, upon his determination that such events have occurred, issue a proclamation declaring that Idaho will not be obligated to comply until the new dates are set by Health and Human Services and/or the United States Congress. The governor shall file such proclamation with the Secretary of State. Additionally, the bill includes a severability clause and declares an emergency, which means the bill will be in effect upon its passage and approval. That's the review of the bill, Senators, and I apologize that took so long. Excuse me. Senators, I'm not going to take time to review all of the reasons I think we're better off with a state insurance exchange rather than defaulting to a federal exchange. You've heard that from me and many others already, but I do want to hit some highlights. I received a call from a nice lady a few days ago encouraging me to vote against House Bill 248. I appreciated very much the fact that she was polite and was willing to listen to my point of view as well as to give me hers. Toward the end of our conversation, she asked me if I had read the Patient Protection and Affordable Care Act. I told her I had not. And she responded that she thought it was unconscionable, or words to that effect, that I and others would be voting on something we had never read. I politely explained to her that I would not be voting on the Patient Protection and Affordable Care Act, that I would be voting on House Bill 248, and that just before she called, I had finished reading it once again. Senators, I wish that I was going to be voting on the Affordable Care Act. That would be such an easy vote for me. I could vote no without giving it a second thought. And I even confess that I could vote no without needing to read the entire act. I wish that were the vote we were going to make today, but it is not. In the minds of many, however, it seems to them that we are. Most of the arguments I hear against the state exchange and the legislation we're considering today are really arguments against the Affordable Care Act. We're told how a state exchange will raise premium rates, how it will mandate coverage that many think are inappropriate, including coverage for certain types of contraceptives. We're told that it will be expensive to administer and that it takes us one step closer to a national single-payer health care system. I admit all of these things, Senators, will happen, and I don't like it a bit. But the most important thing that I will say today is this. Those things are going to happen because the Patient Protection and Affordable Care Act was enacted into law and that efforts to repeal it or declare it unconstitutional have been unsuccessful. It is the Affordable Care Act that is doing those things to us. Enacting a state exchange as opposed to defaulting to a federal exchange is an effort to minimize those negative impacts. And let me say that one more time, please. Enacting a state exchange as opposed to defaulting to a federal exchange is an effort to minimize the negative impacts of the Patient Protection and Affordable Care Act. Senators, we cannot fix it all. I wish we could. We don't have as much flexibility as we would like. I wish we did. But in my mind, the fact that we can't fix all of the things we don't like about the Affordable Care Act doesn't mean that we should not retain control to the extent that we can. We are going to have a health care exchange as mandated by the federal government. It will either be a state-based exchange, a federal exchange, or some combination of the two. I wish there were another option. Many believe there is, and we're criticized for not supporting a free market option. We have a free market option now. Anyone who wishes can buy insurance from a private insurance carrier, and you'll be able to continue to do that after the federally mandated insurance exchange is implemented. Excuse me. Excuse me again. But having free market options available in the states doesn't prevent the federal government from creating a federal exchange for Idaho if we don't create a state exchange. I don't know how else to say that. So take all the arguments against an exchange and send them to the folks in Washington, D.C. They're the only ones who can fix that problem, and it's frustrating. It's as frustrating as can be, but that's where we are. So if we must have either a federal exchange or a state exchange, why opt for a state exchange? That's what this debate should be about. That's the decision we will make today, again, whether to have a state exchange or default to the federal government. Those of us who support a state exchange believe a state exchange will be less costly, less onerous for the citizens of Idaho, provide more product choices, and make better use of the insurance professionals who are in this state. But there's another major reason to support a state exchange over a federal exchange. If you believe President Obama is moving toward a single-payer health care system, and if you don't want that to happen, please consider this question. Would it be easier to move all of the states to one national system if all the states were already defaulting to the same federal health exchange, or would it be easier to move to a single system if states were operating their own state-based exchanges? I believe it would be much more difficult to move to a single national system if many states were operating their own state-based exchanges. Senators, I thank you for being patient with me as I reviewed the bill once again after we had read it, and for making these additional comments. Mr. President, debate is open.
Debate. Hearing no further. Senator Fulcher.
Mr. President, debate the bill.
You have the floor.
Thank you, Mr. President. Good senators, you'll recall that I vigorously opposed Senate Bill 1042, and I vigorously oppose House Bill 248. There are some minor changes, but the effect is the same. This is the voluntary implementation of the Affordable Care Act. And with all due respect to the good senator from 32, we are right now, or very soon, to be voting on the Affordable Care Act. And don't take my word on it. Take a look at page 4 of the bill, starting with line 37. Mr. President, may I read from the bill?
You may.
The exchange shall not prohibit a health carrier from participating in the exchange or prohibit a health benefit plan or stand-alone dental plan from being sold in the exchange so long as a health carrier or health benefit plan or stand-alone dental plan meets all requirements of applicable law. To senators, applicable law is the Affordable Care Act and others that we haven't seen yet. My experience tells me that there's really nothing that I can say right now that is likely to change any minds. My heart tells me that I need to try. I do believe this is the most important issue of my legislative career. Last night I was trying to think of what I was going to say to you today, and I've been struggling to find that message because I really don't want to offend anyone. At the same time, I want to be truthful, but my heart, my mind, and my soul believes this is the wrong thing for Idaho. I continue to hear from majority party colleagues that they don't like Obamacare. Yet, Senate Bill 1042 passed the Senate relatively easily. And this bill, House Bill 248, has passed the body across the rotunda pretty easily. Factors that otherwise we would hold in this chamber as sacred, we have now, in my view, rationalized to insignificance. Things like understanding the costs. Mr. President, good senators, we don't know what the costs are for this. The more I look into the background, the more varied those numbers become. I've heard anywhere and seen data anywhere from $20 million to $70 million. We don't know the cost. We don't know the cost per policy, and there's no guidelines, there's no boundaries in this legislation that would limit that. It might be $4, it might be $54. We don't know. But those costs have been rationalized to insignificance. In terms of understanding the language and the language that impacts this bill, I got the same memo you did approximately 2 weeks ago tomorrow. Health and Human Services released an incremental 700 pages of rules that is also, by the way, applicable law to 248. I haven't read those. I doubt if anyone else here has read those. I don't know what it will force us to do once we pass this. But we have rationalized that into insignificance. The rule review, the oversight piece, that still has not been rectified. Other legislation, we viciously guard that right of rule review. But in this case, we're rationalizing that to insignificance. The privacy concerns, what the government will do with the data that it collects on you and on me and on our constituents, those privacy concerns have been rationalized to insignificance. The legal ramifications that come with being a voluntary, and I underscore the word voluntary because that's what we're doing by passing this bill, being voluntary. Those legal ramifications of that voluntary implementation and what we forfeit by voluntarily doing this, we're rationalizing that to insignificance. However, the most stunning and the most personal to me is the religious liberty and the life provisions, or absence thereof, in this bill or applicable law. We are rationalizing that to insignificance. Good senators, you may recall that we were assured there'd be a trailer bill that would address that. Mr. President, good senators, there is no trailer bill. Now, the session's not over, but it's going to be in a week or so, and there's no trailer bill. You may recall that we were told we have a seat at the table for things like this and other important things to address. Since the passage of 1042, we're now being told we've done the best we can. We've got to play the cards that we're dealt. I repeat, the most stunning rationalization to insignificance to me is the religious liberty and life provisions. That issue alone, for me, takes priority over an exchange, compliance with the federal government versus not. That cost is too high. This has been an amazing process. I've never seen anything like it in the 9 years that I've been here. The drive to this exchange has taken on an intoxicating effect like I've never seen before. We are rationalizing things to insignificance that we would never even consider under other circumstances. But there's hope, and I want to change the tenor of my debate by communicating a sincere hope. And that hope, Mr. President, good senators, is in you. You are good people. You are people of ethics. You are people of character. And together, we'll act. When this system implodes due to the admin burden, and when the costs explode, we will together reconsider this. When the federal government continues to prove that they're not flexible and that there really is no table, we will reconsider our actions. As the costs rise higher than projected, we will seek to hold those accountable. When our constituents cry out that their privacy concerns have been violated, we will try to insulate them. As other states make legal progress, we will try to unhook from this. And when that happens, in my heart, in my mind, I believe it will, I will stand with you. This body has good ethics and good character. And together we will fight against the ramifications of the passage of this bill. A wise man once said that ethics are not governed by rules, but by heart. Ethics are not governed by statute, but by character. It's a matter of principle. The answer has always been and continues to lie with the free market, not regulated activity, with self-sufficiency, not government control. And this will sound familiar to you, Mr. President, good senators, but I'm just one little state senator in one little state trying to do anything I can to keep the strings from the federal puppeteer from being attached to my body and the body of those I serve. There is no rush. We have nothing to gain. We have much to lose. The senator votes no.
For the debate, Senator Nuxall.
Mr. President, to debate the bill.
You have the floor.
Good senators, the patriotism, faith, and abilities of this Senate are unbelievable. So how can we be so divided, seeing the same issue in such different views? The vote on this bill before us is one of the most monumental decisions we shall ever make. To me and many others, the vote on this bill is a question of the start of slavery or freedom. Because of this, my hope is that what I'm about to say will not be disrespectful to anyone on the floor, since I believe that I'm following the path that God has chosen for me to defend my country, my state, and my family. Most of you here are more experienced in the battle of politics than I am, but I must speak according to my beliefs, my heart, my knowledge, and my personal experience. Due to the way the Affordable Care Act was written, it depends on the existence of a state exchange to impose the tax penalty. The state has no control over this. There are many authorities that conclude that the employer mandate applies only in states that create and fund their own exchanges. And Mr. President, if I may quote out of the Heartlander magazine dated 1/10/13, I have about 3 quotes.
Having identified the source, the senator may read.
Morris Thompson, director of the Center of Constitutional Law in Ohio, says, quote, "Under a strict reading of President Obama's law, the states must set up exchanges in order to enforce the mandates and distribute the subsidies. The law does not authorize the federal government to offer tax credits or subsidies through its own exchanges. Rather, it continually refers to, quote, an exchange established by the state." In the same article, Jonathan Adler, a professor at Case Western Reserve University School of Law, concludes that tax credits and subsidies for the purchase of qualifying health insurance plans in state-run exchanges operate as the trigger for enforcement of the Act's employer mandate. He says further that the IRS rule amounts to a new tax that wasn't authorized by Congress. In the same article, the much-respected Congressional Research Service, and there is a handout on that for you, is a nonpartisan group that works exclusively for Congress for over a century. And they noted that without the state-based implementation trigger, there's no tax penalty. And an IRS interpretation that extended tax credits to those who enrolled in federally facilitated exchanges would be contrary to clear congressional intent and likely being deemed invalid. There are many other authorities that are saying this, like Heritage, Cato, ALEC. So in other words, the taxes and penalties threatened to be imposed upon us for not buying insurance, as defined by the Affordable Care Act, are dependent upon each state establishing a state exchange. Without a state exchange in Idaho, there are no penalties for Idahoans. So we continually state that we will have more control with the state exchange. Just how much control does the state have with the state exchange? I want you, if you're willing, to look at the papers I handed out to you today as I walk you through them if you have not already done so. These 4 pages are from Obamacare, dealing with state exchange flexibility, regulations, cost, and enforcement. So on the first page, it starts out with state flexibility. And you can look that up on the website if you want to follow on the website. The website that is right there also. And I'm going to use quotes out of this, or follow this partly, if that's okay, Mr. President.
Having identified the source, the senator may quote.
So, in general, the Secretary shall issue regulations setting standards for meeting the requirements. A, the establishment and operation of exchanges, including shop exchanges. B, the offering of qualified health plans through such exchanges. C, the establishment of the reinsurance and risk adjustment programs under Part 5. And D, such other requirements as the Secretary determines appropriate. And number 2, under consultation, if you will notice, under 1 it says the Secretary shall consult with the National Association of Insurance Commissioners and its members, with health insurance issuers, consumer organizations, and other such individuals as the Secretary selects in a manner designed to ensure balanced representation among interested parties. There is absolutely no consultation with the states regarding establishment of the exchange and the insurance products that are being offered on the exchange. The term flexibility in the title of the section was put there to fool us to think that some flexibility already existed. B, each state that elects at such time in such manner as the Secretary may prescribe to apply the requirements described in subsection A. And then 1, it goes on, the federal standards established. And 2, the Secretary determines. So we have the right to build the store, but we have absolutely no control over the products that we're going to sell. So there's no real flexibility. Then the next section, C, failure to establish, exchange, or implement requirements. If you go down a little bit, it says, the Secretary shall, directly or through agreement with a not-for-profit entity, establish and offer such exchange within the state. Now, it's important to note here that the exchange established by the federal government is not referred to as a state exchange. Rather, it's simply referred to as an exchange, and this is what I was referring to in my other quotes. If the Secretary wanted to call it a state exchange to clearly indicate that whether it is established by the state or by the federal government, it is still considered a state exchange, the wording would have been much different. However, it simply calls the health exchange established by the federal government as exchange. So there is a difference between exchange and state exchange, a difference that has huge implications. Then we have under enforcement authority. We have D, and it says, no interference with state regulatory authority. Nothing in this title shall be construed to preempt any state law that does not prevent the application of the provisions of this title. Is that clear to you? It's very confusing. I think if you take out the word not, it says the opposite of what it's supposed to mean. So, I mean, if you take out the word not, it says what it's supposed to mean, flexibility, but it doesn't. It includes the word not. You try reading that one. It's very confusing. Then in the next part, in general, it says the Secretary shall presume that the exchange meets the standards under this section unless the Secretary determines after completion of the process established under paragraph 2 that the exchange does not comply with such standards. And number 2, process. The Secretary shall establish a process to work with the state to provide assistance necessary to assist the state exchange in coming into compliance with the standards for approval under this section. So that's the entire section on flexibility. So unless you see something clearly articulated in there, we can't do it. You may hear many benefits that the state will derive from setting up their own exchange, but just because we want it so doesn't make it so. And then it gets worse. We could go through some additional federal requirements that are being put upon us if we adopt a state exchange. In fact, you might find it interesting to put in the term each state shall in the website and review many of the requirements that are put upon the state exchange. So some additional federal requirements if we keep going. Section 1252, rating reforms must apply uniformly to all health insurers and group health plans. Any standard or requirement adopted by a state pursuant to this title or any amendment made by this title shall be applied uniformly to all health plans in each insurance market to which the standard and requirements apply. Section 2002 is transition planning and oversight. If you read there, each state shall submit to the Secretary for the Secretary's approval the income eligibility thresholds. Then the third part, cost. In a letter to Governor Otter from Kathleen Sebelius dated January 3rd, 2013, if I could quote out of that, Mr. President.
Having identified the source, the Senator may read.
State exchange requirements. Each state exchange must demonstrate legal authority for all necessary state-based exchange functions as described in the Affordable Care Act, including financial sustainability and the appropriate authority to certify quality health plans by March 15, 2013. Does this sound like a federal government who's willing to assume all the costs for establishing and maintaining the exchange? And then number 4, under the Obamacare Act, risk adjustment, 1343. Number 1, each state shall assess a charge on health plans and health insurance issuers. Number 2, and this is not on your paper, is high actuarial risk plans. Each state shall provide a payment to health plans and health insurance issuers. Then Section 1413, streamlining of procedures for enrollment through an exchange and state Medicaid CHIP and mental and health subsidy programs. Under 1, each state shall develop for all applicable state health subsidy programs a secure electronic interface allowing an exchange of data. So forth on that. Under enforcement, Section 1401, I just want to point you to number 2, premium assistant amount. And it says here, all monthly premiums for such month for one or more qualified health plans offered in the individual market within a state which cover the taxpayer's spouse, or any dependent of the taxpayer in which were enrolled in through an exchange established by the state under 1311 of the Patient Protection and Affordable Care Act. What I want to point out here is this terminology we see is, I've referred to before, is that only through a state exchange, an exchange established by the state, needs to be pointed out. It's not such exchange within the state, so there's a difference between the two exchanges. As that one, as such exchange within the state is quoted in Section 1321, the part where it says for failure to establish an exchange. So there are differences between the exchanges. And I don't know if, you have actually viewed that before. And so that was one reason I wanted to go through that. So it gives us an opportunity to take advantage of seeing whether what we think is really what is. Does the state exchange give us control on life and religion? Does it have flexibility over costs and regulation? So again, my concern is that there's no explicit protection for unborn life and for freedom of conscience in HB 248 because of mandatory health insurance coverage of contraception, sterilization, and Plan B and ELA. The state has no control over preventative services. Forcing us to buy insurance through a state exchange is an attack on our religious freedom and conscience rights, since there is no opting out of these preventative services in the required health benefit plan set up by HHS. Because of Idaho's abortion opt-out language passed in 2011, the Attorney General's legal opinion states that under a state or federal exchange, our insurance companies may not provide coverage for surgical abortions or RU 486, but under a state exchange, they would be required to provide for Plan B and ELA since they are considered contraceptives. But Plan B and Ella are also potential abortifacients since they can prevent implementation of a fertilized egg, an unborn baby. In an academic review dated February of 2013, LifeSite News by Patrick Crane, Mr. President, if I may use that source.
Having identified the source, Senator may read.
Dr. James Trussell, a member of Planned Parenthood's medical committee, and one of the leading authorities on emergency contraception, has said that doctors have a duty to inform women that emergency contraception could prevent a newly conceived embryo from implanting in the womb, therefore an abortion. Insurance companies will be required to provide coverage for emergency contraception, whether we have a federal exchange or state exchange, but the employer mandate tax can only be imposed upon the state exchange. So if the tax cannot be imposed, then one could avoid paying for insurance that is against life, liberty, and property. In 2010, we passed the Health Freedom Act. And in 2002, by passing SJR 104, the legislature petitioned Congress to reject the HHS mandate that required those who sponsor, purchase, and issue health insurance plans should not be forced to violate their deeply held moral and religious convictions in order to take part in any health care system that violates their belief in the sanctity of life. Senators, it is the duty, our duty, the duty of state government, according to statute and code, to protect us. Our lives, first of all, and our freedom of religion, and the most cherished of American freedoms, our religion, freedom of religion. Are you willing to leave this up to the mercy of the federal government that is now the most anti-life government we've ever had? I ask you, what is more important than protecting life? If we who are a pro-life state cannot even vote for a pro-life, pro-religious freedom amendment, what control do we have? If we do not protect life at the state level, then we have no rights at all under our state government. We need to say no and wait. It does make one wonder what motives are behind the push for a state exchange if we have no control over life. What monetary or political gain is there to go against life, liberty, and property? Good senators, many of you have said that your heart is with us on these issues, and I truly believe that. But will you join your hearts to your faith and these facts and join us? George Washington said, "Of all the dispositions that lead to political prosperity, our religion and morality are the indispensable supporters. In a world without God or religion, the strongest thing is the state, and especially and most obviously the state that banishes God. We are bending the knee before the secular state." Thank you, Mr. President.
For the debate, Senator Nonini.
Thank you, Mr. President. Would you ask the senator from 32 if he'd yield to a couple questions, please?
Senator Tippett, would you yield?
Mr. President, Senator, I would yield.
Senator Nonini for the inquiry.
Thank you, Mr. President, and thank you, good senator. I wrote down two words in quotation marks in your opening, less costly. And I asked this question during the debate on 1042. I'll ask it again. What sources might you provide me or provide this body that show that a state exchange is less costly?
Senator Tippett.
Mr. President, Senator, when I refer to the exchange being less costly, I'm referring to the cost of administration. And I said I believe that we believe that it will be less costly. There's no guarantees. We don't know how much it's going to cost to administer the program. But we believe it'll be on the order of what Nevada's charging, and that's $7 and something per person per month. We think it will be that or less. That's the best guess. I know that's been a bit of a moving target, but we believe that will be significantly less than the 3.5% that the federal government right now plans to charge. Now, I know that could also change depending on their experience, but we believe, there are no guarantees, I admit that we can administer the plan in a less costly manner than the federal government. And I think history would show typically the state can administer these programs for less money than the federal government.
Thank you, good Senator. Mr. President, for one more inquiry, please.
Senator Tippett.
Mr. President, I would yield.
Senator Nonini.
Thank you, Mr. President. Good Senator. Also, you read from the bill in your opening, and it's in the bill. It says amounts lawfully owed to the exchange. This exchange would be able to collect those. Could you share with the body what would those amounts be and who would owe those amounts to the exchange that would give the exchange a lawful right to go collect those?
Well, Mr. President and Senator from 3, one of the costs that come to my mind is, of course, the cost of administration. So the exchange will be collecting those fees from the providers. That's my assumption. There may be other costs. I'm not aware of the intricacies of the operation of the exchange. Senator, we can get more information if you need it.
Thank you, Mr. President. Thank you, Senator.
Thank you.
For the debate. Senator Pierce.
Mr. President, would the good gentleman from 32 yield to a couple?
Senator Tippett.
3 questions.
Mr. President, I would yield to one question at a time. Thanks, Senator.
Senator Pierce.
Thank you. Senator from 32. How can we be assured that our state exchange will not do the dirty work of reporting Idaho citizens for noncompliance?
Senator Tippett.
Is there any insurance in that in 248?
Mr. President and Senator, I can't see your number. I apologize.
9.
Senator from 9. Could you be a little more specific? Noncompliance for what?
Senator Pierce.
Mr. President, Senator from 32. When the exchange gets going and people either drop off and no longer participate, or we become aware of them not being participating in the law, I find where we've been told that state exchanges will report to the federal government noncompliance. I'm asking here, and we've been assured here before that Idaho won't do that, and I'm asking where in 248 that we're assured that that we won't be reporting noncompliance and those problems to the federal government.
Senator Tippett.
Mr. President and Senator from 9, I'm not sure that there are any assurances that the exchange won't be reporting the noncompliance to the federal government. If you've heard that, I don't believe it came from me. That may be true, but we would have to verify that. But I believe there may be some sharing of information. However, if we default to a federal exchange, obviously the federal government will have the information. So that situation certainly is no worse under a state exchange than it would be with a federal exchange. With a federal exchange, they've got the information directly, of course.
Thank you, Mr. President. For a follow-up?
Senator Tippett.
I would yield, Mr. President.
Senator Pierce.
I, too, am unsure how the subsidies that will be paid to the exchange will trigger penalties on employers. Can you explain that process to me?
Senator Tippett.
Mr. President and Senator from 9, first of all, it'll be the same whether it's a state exchange or a federal exchange. I know some make the contention that this will only happen with a state exchange, not a federal exchange. I think others, and I'll have the ability to address that later too, but we think that's not the case. If employers are not providing insurance, and my understanding is, and their employees access the services and receive premium subsidies through the exchange, then the employer, whether it's a state exchange or a federal exchange, will be subject to penalties.
Thank you. My final inquiry?
I would yield, Mr. President.
Senator Pierce.
Will there be any financial benefit for our state insurance companies if we do a state exchange over a federal exchange?
Senator Tippett.
Mr. President and Senator from 9, possibly. One of the benefits is that our state exchange will be an open exchange. Anyone who meets the criteria can bring an insurance product to the exchange and sell it through the exchange, as well as on the open market. We're not sure that that will be the case with a federal exchange. It appears as though initially they'll be pretty generous about allowing these products to be sold, but they've also said they'll evaluate at some point in time, and they may, and we think it's a likelihood that they'll reduce the number of products that are available and the number of carriers. So we think that will benefit, as well as I mentioned earlier, we believe administration costs will be lower with a state exchange as opposed to a federal exchange.
Thank you.
For the debate.
Mr. President.
Hearing no further debate. Senator Vick.
Thank you, Mr. President. Well, I think that we've heard some good arguments as to why we should oppose the exchange. But I would like to take a few minutes and talk to those who oppose Obamacare but support them at the exchange, and try to give them one reason to change their mind. I have struggled, honestly, to figure out why people who support or who oppose the Affordable Care Act support the exchange. These are good people. These are my friends, and we agree on many, many things. So I really have struggled to figure out why they support a state exchange. Here's what the proponents of the exchange say. If we're going to have an exchange, and we've heard this several times already this morning, it is better to have a state exchange. It's better to have Idahoans run it. And they use the example of the DEQ, that people would rather deal with people here in Idaho than they would deal with the feds. And I agree with that. But I do have one problem with that, and that is we have the DEQ and we still have the EPA. The EPA is now 43 years old, and I don't see it going anywhere. And my goal is not to make the Affordable Care Act more tolerable. My goal is to eliminate the Affordable Care Act, to have it stopped. The next point that proponents make that I want to address is the issue of it's the law. Because many supporters say, well, we need to do a state-based exchange because Obamacare is the law of the land. So I did some homework. I'm kind of an amateur history buff, and so I did some homework. And when I look through the history of this country to see what's been done to change bad laws, I don't see examples. I didn't find examples where we changed a bad law by complying with the law. This strategy that I see here of resisting by complying is new, and I honestly don't expect it to have much success. Well, what does history teach us? I'll start with a story we all know well. In the very foundation of this country, when we were colonies, the British government imposed taxation without representation. And what was our reaction? It wasn't, let us run the tax system because we can do it better. No, they had a tea party. And later on in our history, when the Supreme Court upheld the Fugitive Slave Act, did those free states, those states that opposed slavery, did they say, well, I guess the best we can do is when those slaves get into our free states is make sure that we take care of them well, clean them up, and send them back home to their slave owners? No, they did not. They formed the Underground Railroad, and they got those people to Canada. Those escaped slaves, they helped them escape. During the Civil Rights Movement, when Rosa Parks became famous, and as a matter of fact sparked the Civil Rights Movement, did she do that by taking the very best seat at the back of the bus? No, she did it by sitting at the front of the bus, by not complying with the law. History teaches us we don't change a bad law by complying with it. Now, if you want Obamacare to be run in the best possible way for people in Idaho, you may want to vote for the state exchange, because we may do it very well, do it better. But if you want to reverse Obamacare, put an end to it, and encourage others to fight Obamacare, then you need to vote no. Is that all that needs to be done? Is to say no to the state-based exchange? No. But it is part of what needs to be done. Because history again teaches us we don't fight a bad law by complying with it. And make no mistake, we have heard this in every avenue so far this morning. House Bill 248 complies with the Affordable Care Act. Are there still challenges ahead? Yes, there are. But if we give in at this opportunity to say no, we send a message that it's not worth the fight. But if we stand up and say we are willing to fight, we may embolden a citizen or 2 or 10 or 100 to join us in that fight. That, historically, is how you stop an unjust law. To me, taxing people for failing to buy insurance is unjust. What are a few other laws that were unjust? That there is no way we could accept now. But at the time, somebody thought they were a good idea, and they were upheld by the Supreme Court of the United States. And they were the law of the land. Well, I touched on a couple of these a little bit already, but the Fugitive Slave Act, we also, Japanese internment camps were held to be constitutional, and the separate but equal doctrine. And I'm going to just focus on one of these today, and that's the separate but equal doctrine. It stated that for different races of people, you could have separate accommodations as long as they were equal. Segregation. The law was upheld by the Supreme Court in the case of Plessy versus Ferguson in 1896. How long did the United States live under this law? For almost 60 years. It was complied with and never changed. In nearly 60 years, the federal government never rewrote the law. When did it change? When those who were adversely affected by it stood up and said, no. When they said, we are going to go down and enroll our kids in the neighborhood schools, in the schools that we should be able to go to. It wasn't those who complied with the separate but equal law that changed it, but those who defied it. In essence, the ruling in Brown versus the Board of Education of Kansas in 1954 said separate but equal was not equal. And it's interesting to note that this is the case that it's named after because of all the states who had this law. Kansas was doing the best job of providing equal schools. Kind of like, in my mind, how we might do the best job of running a state exchange. But when something is unjust, you don't get much credit for making a bad thing better. And to me, making a bad thing better is not good enough. But something else is missing in this debate as well. What I haven't heard from the proponents of this bill is what their next step is. The proponents haven't told us, once we implement the state-based exchange, how do we stop Obamacare? How do we roll it back? I haven't seen it in any of their dozens of handouts that I have received. Why is that? Because they don't have a plan to stop Obamacare. But they do have a next step. Their next step is Medicaid expansion. Their next step is full implementation in Idaho. That is what the healthcare industry wants. The supporters of the state-based exchange don't have a plan to stop Obamacare. Their plan is to implement it. One of the other points that they make is that nobody has done more to fight Obamacare than Idaho. Is the fight over? Are we waving the white flag of surrender? I believe that is what the supporters of this are saying. We fought and we've lost, so let's comply. Those that fought segregation didn't say what we want is separate, but really, really equal schools. What they wanted was for segregation to go away. They wanted integrated schools. They wanted equality, and in order to get that, they had to defy the unjust law. In the same way, I don't want a slightly improved Obamacare. I want Obamacare to go away. And I understand this is just a first step, but it's a necessary first step. And I want to close with this. Well, I grew up in rattlesnake country. We knew there were snakes out there. We killed a few rattlesnakes in our yard, and we killed many rattlesnakes in our fields. And how did we deal with that? Well, we wore high-top leather boots. You'd probably call them cowboy boots, for protection. One summer, I personally killed 13 rattlesnakes. But you know what I didn't do? You know what my family didn't do? We didn't bring the snakes into the house to try to control them or to try to tame them. We didn't bring them into the house so we could keep an eye on them. We used boots. We had cats and dogs who, although they don't like each other, they don't like snakes either. And we did all of these things to keep the snakes at bay. The Affordable Care Act is unpopular, unworkable, and unaffordable. I can see in no way how we are keeping it at bay by implementing the state-based exchange. We are inviting it into the House. Because of federal law, Obamacare currently is the law in Idaho. But by passage of this bill, for the very first time, it will be the law of Idaho. And that is something I cannot do. And I will be voting no.
For the debate, Senator Nonini.
Thank you, Mr. President. 23-12 a few weeks ago. I bet it's not going to be much different today, Senators, but I'm going to have my say. I appreciate the respect that we've shown to each other. I would expect that to continue, and I'll do my best, Mr. President. But 23-12, facts versus emotions. Interesting, isn't it? You know, self-supporting is in the legislation. Says it has to be self-supporting. The exchange needs to be self-supporting. We understand by 2015. Now, you know, there's a file. I've got a file down in my desk drawer that's probably 4 times this. This is just what I brought up here to read today. And I probably won't, because you don't want to hear it. Because it's 23-12. The vote isn't going to change. Maybe one of you will see the light, or our side of the story, I guess. But when I ask questions like, where is the information coming from when they stand up and say it's going to be less costly? Can you provide me some sources? Can you provide me some credible resources that say it might be less costly? And in my short time here in this body, 9 or 10 weeks, I have really grown to respect the senator from 32. And will publicly say, embarrassed by my actions last May, and in something that you're probably all aware of. He's quite a gentleman. But still can't answer my question. Still can't answer the question. But yet when I feel I provide credible sources to say a state exchange will be more costly than a federal exchange, I feel that it's being dismissed. You don't want to hear those credible sources. I just wish along this debate and along this couple of months that we've been here, when I've continued to ask that question, that I could get some sources. Now, are those sources vendors? Are they the Levitt Group out of Utah? Are they the insurance companies that do business in this state? Are they the hospitals that do business in this state? I don't know, because no one will say where those sources come from. But that there are, and I think I wrote down again for the second time in a month, the gentleman from 32's answer, and he is consistent, our best guess. Our best guess. Well, I think I have information that I feel are credible sources. Some of you might not, especially my friends on the other side of the political aisle, because they come from what I feel are credible think tanks, but they are conservative think tanks. They're the Heritage Foundation, the Goldwater Institute, and ones that maybe you don't feel are as credible, but I would hope that my colleagues on the same side of the political aisle would feel that they're credible sources. So I feel that I give the credible sources to say a state exchange would probably not be less costly, it would probably be more costly. But yet I feel that that falls on deaf ears. I've had the pages pass out some information that I would like to go over. And the first thing is a letter from an economics professor at Northwest Nazarene, and having identified the source, Mr. President, might I cite a couple of points there, please, sir?
You may, Senator.
Thank you, Mr. President. Now, I won't read the 3 or 4 paragraphs that I read a month ago. That's why this time I made you your own copies, so you would all have those copies in front of you. Now, I think this is a credible person. I've spoke to the gentleman on the phone. I've never met him in person. He's an economics professor out at NNU, but he's got a pretty good piece. And I would hope you would look as we continue this debate, albeit probably considerably shorter than it was a month ago, and I'll be happy with that, as I feel my other 34 colleagues in this body and Mr. President and staff will be too. But he talks about moral hazards in the group health insurance marketplace. I think this is a credible source. I think it should weigh on your decisions here today. I would hope you'd take a look at that over the next short period of time. Again, he touches on important points that I believe a state exchange, and in his paper, cites the reasons why a state exchange will be more costly, not less costly. So I have trouble with that issue. When I ask the question, where's your sources? In fact, I talked to a lobbyist just yesterday. I heard him say that a state exchange would be lower cost, and I asked him the same question: where'd that source come from? Where did you get that information? And he said, from the governor, excuse me, Mr. President, the gentleman on the second floor's worksheet. What's that? I haven't seen that worksheet. Now, I know the gentleman on the second floor has worked hard on this issue for the better part of a couple of years, as we knew this was coming down the pike. But again, all I want is some credible sources to prove this, not answers like "we don't know" or "it's our best guess." That's not good enough for me, folks. The other, excuse me, Mr. President, senators, the other piece that I'd like to bring your attention to is a piece from the Idaho Statesman dated March 4, 2013, that the page is passed out. Idaho health insurers pile up surpluses. Now, the reason I bring this up is because we've heard in the debate on this legislation that we need to protect our Idaho companies. We need to protect our Idaho companies. Well, if you don't want to read the whole article, because it's about a page and a half, maybe a page and 2/3, just look at the graph down in the lower left-hand corner on the front page. Just look at that graph. And it lists the 2 major insurance companies of Idaho and how their reserves have grown in the last few years. In fact, if you read the article and look at parts of the article, it'll say in the article that one of the company's reserves have grown at 5 times the minimum state requirement. 5 times the minimum state requirement. While at the same time, over the last 3 years, we have seen our premiums for health insurance go up 5% in 12, 8.3% in 13, and a projected 6.6% in 2014. But yet, we are told by doing a state exchange, we are going to protect our Idaho companies. Well, I would submit to this body that these companies don't need a lot of help. They seem to be doing quite well on their own. In fact, it seems to be quite a cherry to be picked when you get this business of the state of Idaho, because the one carrier's steep increase in revenues and surpluses has only happened since they picked up this piece of business. Now, they'll say in the article, we never know when we're going to have a big claim to pay. Oh, a big claim to pay at a $500 million surplus. If you do want to take a couple minutes to look at the article, look at page 2 that talks about their reinsurance program, that they're really capped at $2 million because after $2 million, there's reinsurance that kicks in. The third piece I passed out was out of the Statesman on 3/2 of 13. Steady. Idaho among nations worse for hospital inflation. I guess another business that we're trying to protect here, you know, it just boggles my mind that we hear in debate that we're going to protect Idaho businesses by doing a state exchange. Again, I think these companies, whether they're the insurers or those providing medical care, are doing quite well on their own. In fact, I think at the sacrifice and the detriment in the expense of Idaho residents, Idaho taxpayers, our constituents. Facts from credible sources and emotional issues. I guess if we're going to look at facts or weigh those facts in, maybe 23 to 12 won't be the number. Maybe it won't be. Maybe it'll be 20 to 15. Maybe there'll be a couple people. I don't think so, Mr. President. I don't think so, Senators. If I was a betting man, I would say 23-12, maybe 24-11, maybe 25-10. But at any rate, you know, the other thing that bothers me a little bit about this, and I've only been around here for this is just my 9th year. Some of you have been here twice that length or longer. Some of you have been here considerably less than those 9 years. But in my 8 plus almost 9 years here, I've never seen an issue like this touch on emotions like it has, see as many people taken out for little meetings and lunches, and one thing that really bothered me the other day, which I said something to the good chairman from 32 and also the good senator from 34, were lobbyists mocking people.
Mr. Chairman.
Sir Hill.
Mr. Chairman, I think our rules require us to discuss the merits of the bill itself. And I would request that, please.
Senator Nonini.
You know, thank you, Mr. President. We've also talked about free market solutions. You know, there is still going to be an insurance marketplace. The good senator from 32 mentioned that in his opening debate. We all know that. We all know that the large group marketplace will still exist. There will still be a private insurance marketplace. And I'll try to stay on task here and not get off the merits of the bill. You know, it's frustrating, I guess, what side you're on here. You know, I guess I'll just wrap it up with saying, and some of you will find this kind of silly, but it's the way I am. When I get up in the morning, and depending on how I feel, I'll look at what suit I want to put on. I'll look at what tie I want to wear, what shirt I want to wear. And you know what, Senators? You know what, this morning? I got the darkest suit out I could find. I got the darkest cuffs I could find, the darkest tie, the gray shirt, because, Mr. President and Senators, I believe this is a dark day for Idaho. I believe this is a dark day in this building. I am just so frustrated by this that I feel like I'm in mourning, because we're losing something here this morning. We are losing our freedom. We are giving up our sovereignty to the federal government. Now, what's interesting is you could read right from the intent, the purpose and the intent. Lines 19 through 21. It is the public policy of the state of Idaho to actively resist federal actions that would limit or override state sovereignty under the 10th Amendment. You know, those are just words put in by the bill drafter. Those are just words put in by the bill drafter. They're nothing more than that. But yet when I read, again, sources that I think are credible sources, they say just the opposite. They say we're giving up our sovereignty. So who's right? Who's right here? The bill drafters, the people that put this bill together by putting a few words in here, or those sources that have read the bill? The good senator, the floor sponsor, said he has not read the Affordable Care Act, and sources say that by adopting a state exchange, we are giving up our state sovereignty. You know, there were more things I could say, but it's 23:12 at best again. Maybe we pick up one or two. But again, the dark suit, the dark feeling, the gray shirt. I mean, I like bright ties. I like all that stuff. I like pink ties, but today's not a day to wear bright-colored clothes. Today's a day to feel in mourning that we are really going to probably pass this piece of legislation and send it down to the gentleman on the second floor. It is beyond comparison to me in my short time here, and I hope if I spend more time in this body that we never have to deal with a piece of legislation like this again. And I can go home and face my constituents that have been adamantly opposed to us doing anything like this and feel good about myself. And I guess I look for a day when I can wear a brighter shirt and a brighter tie and feel better about what we're doing in this body.
For the debate, Senator Rice.
Mr. President, members of the Senate, I just wanted to go over a couple of things. My father did a lot of criminal work in his practice over the years as I was growing up, including criminal tax defense. Some of that was here in Idaho, and some of that was in other parts of the country. And it included meeting with attorneys that focused their entire practice on that. And I recall one in particular who made arguments about the Internal Revenue Code based on a literal reading of particular words in particular ways that the courts across the country uniformly rejected. And they uniformly rejected them because they ignored the natural meaning of other parts of the Internal Revenue Code. This was an attorney that was admitted to practice in front of virtually every circuit court of appeals in the country. We've talked a little bit today about some particular things in the Internal Revenue, or in the United States Code with regard to the exchanges. And Mr. President, if I might quote from the United States Code.
That's a lot to quote from, but if you narrow it down a little bit, we'll allow it.
How about 42 U.S.C. subsection 18041, subpart C,
That's
subpart
better.
1, B,
Getting better all the time.
double I, Roman numeral 2. It reads, "The Secretary shall directly or through agreement with a not-for-profit entity establish and operate such exchange within the state." It can't possibly be such exchange if it doesn't do what the exchange if it would do if it were established by the state. That's the first point. The second point is that the exchanges are not state exchanges or federal exchanges. The United States Code in section 18031, paragraph B, specifically provides that they are American health benefit exchanges. Those are what have those functions. Unfortunately, in what sometimes happens with lawyers, we get some of us that chase rabbits down holes. And that has happened with some competent lawyers across the country in this instance. The employer penalties apply whether it's a federal created exchange or a state created exchange. They will. Ultimately, that attorney that I was talking about on the tax matters was held to be bringing frivolous arguments in federal court and was sanctioned. This argument is no better. I have a long family history and tradition of standing up for freedom. It started before the foundation of our nation, or well, maybe it was the basis of much of the foundation. 4 of my direct ancestors were barons who forced King John to sign the Magna Carta. 7 of them were sureties to ensure that he abided by it. I had an ancestor that served in the North Carolina provincial legislature that told King George, "Enough is enough, we're done." I value that heritage. I value freedom. My sentiments about the Affordable Care Act and its excesses are similar to those of the opponents of this exchange bill. But this exchange bill does not implement the Affordable Care Act. It doesn't. It's already will be implemented in full with or without this bill. What this bill does is it says, shall we, as a state, continue to stand between our citizens and the federal government in every way we can? Or will we open the door to the individual homes and lives of our citizens and say to the federal government, go in? That's what this bill does. That's the difference. You know, there's been much said in emails and discussions about a lack of anything that the state would be able to decide. There are a number of specific things identified in the statutes that the state would decide, including who gets to list their policies on the exchange. But one of the things that has been true for 947 years of our legal history, which dates back to William the Conqueror in England in 1066, is that it is impossible to write laws that do not have loopholes. We deal with loopholes every single session. We pass laws to close loopholes. We passed one yesterday dealing with bankruptcy to close in part a loophole. Lawyers find them. They exist all over the place in the regulations and the statute of the Affordable Care Act in ways that allow a state exchange and the states themselves to have the ability to act in ways that protect the citizens of the state. That's the truth about this bill. Those are facts. I'm not going to stand back and open the door for the federal government and tell them, go into the homes of the citizens of the state of Idaho. Do an exchange. Do whatever you will with them. Do what you will with the businesses of the state of Idaho. I will stand silent and mute and on the sidelines. Thank you.
For the debate, Senator Stinnett.
Thank you, Mr. President. Senators, I know as we get into, I don't want to think about how long we've been talking about this. I understand how heated and passionate and deep this has become for all of us. We've certainly spent a great deal of time on it. But I just want to caution as a reminder, because we've all invested a great deal of time and thought and research about this issue, we have to remember that probably no one of us is more or less knowledgeable or more or less superior than any other here on this issue. I'm sure we all feel our position is the enlightened position, and we would all be correct, because we're representing the diversity of our people, as it should be, and as good governing should be. This bill represents a lot of due diligence and a tremendous amount of compromise from this entire legislature, and we should honor that, regardless of our position. So in final, I'd like to say I happen to be proud and pleased to support this bill. Thank you.
For the debate. Hearing no further. Senator Nuxall, for what reason do you rise?
To debate the second time.
Does any senator wish to debate for the first time? Senator Thane.
Thank you, Mr. Chairman. I've been really have enjoyed this morning listening to my fellow senators express their opinions, and I've honored to be part of this body. I don't think that I'll have anything as wise to say as what I've heard, but nonetheless, I do feel like that I do need to stand up, and because I do have an opportunity to be here today and express my opinion. There are those that aren't in this body, the citizens that we represent, that feel quite frustrated. And I'd like to give them some hope on how we could move ahead in the future. I tend to be like most legislators. We like to find solutions to problems. And this debate has been, not this debate, but this issue in particular, has been particularly frustrating for me because, as everyone recognizes and seems to acknowledge, there's a lack of a solution here. I do believe there's a third way forward that I'd like to explain both to the voters, and I think that we'll have to take this up as time moves on. This issue of health care costs will continue to come back year after year after year until we started adopting some policies that actually empower the people. When we go through the history of the last 60 years of health care costs, what we find is that during the Korean War period, when there were wage and price controls, that health benefits were offered by employers to supplement the wages of the employees. What that morphed into, especially with the passage of Medicare and Medicaid, is that we really developed a very strong third-party payer system in this country. And the third-party payer system has insurance companies and federal programs that control most of the spending and therefore make most of the choices. But as Mitch Daniels pointed out in an article in the Wall Street Journal, that the system we have right now is a perfectly designed machine to overconsume and overutilize. So as we move forward, we will have to start empowering the consumers if we want to stabilize these costs. We've actually taken, there's been 2 or 3 bills on the floor of this body this year that have moved that direction. So there's some positive signs. There's some positive signs that the Department of Medicaid is actually moving towards some managed care. So there are some positive things that I can look toward. But one of the reasons that I believe that a federal exchange would actually be better is because there are a lot of citizens out there that do not want to participate in a new entitlement program. And what an entitlement program does is it takes the wealth created by a person who did create it and transfers it to someone else who did not create it. They want to be responsible. They don't want to be punished for being responsible for their own care. So I just want to share with you some facts that I got from the research assistant here at the Legislative Research Library. I've tried to get some of this information from the Department of Insurance over the last couple of months, and I haven't been very successful, and the research assistant was not either. But said that there's approximately 366,000 people that fall between 133% and 400% of poverty. And the reason I'm sharing with you these facts is to get an idea of how many people might be using the exchange, or at least initially. Of those, 232,670 have employer-based insurance, over 9,000 have military insurance, 15,000 are on Medicaid, and 4,000 are on Medicare. And these are people under the age of 64 or 64 and under. So what that leaves you with is about 103,000 people that would be eligible to go to the exchange to get subsidized insurance. With about 2.66 members per household, so we could get the number of policies that might be, that's somewhere around 40,000 policies. If there's a large percentage of the people in Idaho that want to boycott the exchange, that number could drop even further, maybe even under 20,000 or 15,000. And I don't know what the cost of the exchange might be, but I think the people of the state of Idaho have the possibility of boycotting the exchange, and I don't think it could fund itself. So that's the option I'm leaving to some of the people that might be listening to this debate, because I too think that the vote won't be much different than last time, but I would like to leave a path forward both for the citizens of the state and some of the issues that we need to address in the years to come. Thank you, Mr. President.
For the debate, Senator Durst.
Thank you, Mr. President. Just a very short debate. I'm tired of hearing myself, so I can't imagine how others must be feeling. Minute of candor. And Voltaire said that perfect is the enemy of the good. And that's really a phrase that I've been struggling with. It's one of the lessons I learned my freshman year in the House, was not to make a perfect, just because a bill wasn't quite perfect didn't mean it wasn't good enough to pass. And I've struggled with that with this legislation because, ultimately I support a state exchange. I think that's the right approach for our state, and I think that's what would be best. And so I've had these internal debates fighting with myself as to which side of me was going to win. And for some reason, I keep coming down on the, well, this isn't good enough. And I think, well, is this, because do I want it to make it perfect? And I guess what I'm thinking about is not a quest for perfection, but a quest for acceptance. And let me just kind of tell you, just briefly, the areas of this legislation that I think are particularly weak and why they're leading me to the place where I can't support this bill. I appreciate that the other side of the rotunda had some efforts to improve the legislation and add some oversight, and I think those were good things. But one of the things that they refused to address was the issue of consumer protections. And, Mr. President, if I may read, I've got a newspaper article from the Idaho Statesman on the date of March 4th.
Having identified the source, Senator may read.
Thank you, Mr. President. The article states, Bedke R. Oakley said he understands that stretching out the process means another Senate committee hearing and another Senate floor debate after 6 hours talk fest on February 21st. But he said giving opponents a chance to tweak a single bill will make the results less cumbersome and might even pick up votes. He says, quote, any new ideas have to be in good faith, that is to say, no poison pills. Bedke said, quote, I am all about cleaner, streamlined approach. Amendments could include a hat tip to Oklahoma's lawsuit, which attempts to bring the Affordable Care Act down like a Jenga tower by removing the tax credits and subsidize the support affordable. But Wood, chairman of the House committee, said, quote, hostile amendments to put the rulemaking process under the direct authority of the legislature or limit the monthly fees for customers are unacceptable. That last sentence is the one that's really got me stuck. Because my question is, and I believe the chairman of the Germain Committee on this side of the rotunda, the senator from 32, has done a fantastic job. I think he's really done a fair job of shepherding this bill through. I think he's done a fair job listening to testimony. And I take him at his word when he says he has to honor the process. And I believe that he does honor the process. He's done a good job. The problem is that we have to have mutual concurrence on the other side of the rotunda. And for me, what would make this legislation acceptable is knowing that I can protect consumers from having to be gouged to pay for the operation of this exchange. I read, according to the chairman of the Germain Committee on the other side of the rotunda, that that's not happening. That there will be no amendments, even if we let this bill pass. No trailer bill, no additional legislation next session will ever get through his committee that does that. That is where I draw the line. That is why I cannot support House Bill 248. If I had assurances that that legislation would be given a good faith negotiation and a good faith effort to be passed, I'd be okay with it. I'd say, you know, I'll take my chances. But reading in black and white that any restriction on the consumer fees is not something that can be added, is not acceptable to me, and I'll be voting no.
Further debate. Senator Mortimer.
Thank you, Mr. President. I want to also compliment all of the senators that have debated this issue. I feel very inadequate in being able to maybe express my feelings. But I do think that there are some issues that maybe have not been addressed. And that may seem like perhaps pretty unreasonable to assume that there's something that hasn't been addressed. It was interesting after our debate of Senate Bill 1042 that I happened to be at a gathering, and I happened to be with our state treasurer. And we were talking about the length of the debate and the struggles that we had had in the House, in this body. And he said, it's interesting. He said, I was just contacted by Moody's about the estate exchange. And then he didn't really elaborate too much. And I got thinking, and why would that be? And it's pretty evident to me, having been in the financial world and so on, that it's because it, in my opinion, is a substantial contingent liability. Now, I know, and we'll get to that in a minute. Let me just talk to you a little bit about contingent liabilities. And I'm going to just quote, Mr. President, or paraphrase from a little work that I did on Investopedia and then, of course, dummies.com. And that seemed like appropriate. But talking about contingent liabilities. Contingent liabilities are possible financial obligations that may be incurred by an institution or organization contingent upon the result of a future event. These potential costs can be recorded on the balance sheet of the organization and are ranked in order of likelihood that such contingencies will come to fruition. And then it says that there are different rankings: probable, reasonably probable, remote. Here's some other things. Examples of contingent liabilities are acts of employees, credit guarantees, incomplete contracts, third-party indemnities, unfilled purchase orders, and a few others. As a businessman, I've had my experience with contingent liabilities. And sometimes I've been able to get past them, and sometimes I haven't. But many of you know that whenever you go get a loan, and particularly if you're doing it through a business entity, there's typically going to be a personal guarantee. And I'm just going to look at the bill for just a minute in regards to contingent liabilities, if I could, Mr. President.
Having identified the source, the senator may read.
I know that the bill, and I want to basically indicate that I think this bill is a lot better than the bill we had before. There's been a lot of good work here. And there's been an attempt to limit our liability. And part of that is in Section 416102 that basically says that the state will actively resist. There's another section that says that basically in 6104 that it's an independent corporate body of politic. But then again, it says that it's performing an essential public function. It brings the state back into it. And then in 6105, it talks about that the state of Idaho shall not be liable for any obligations. Any of you that have been in business know that you cannot, even in a document, limit certain liabilities. Contingent liabilities, because of all of the unknowns. I express to you that this is a significant contingent liability to our state. We are obligating our state, I believe, both financially and morally, to some of the things that we would not like to do. I'd like to just continue on. Besides the contingent liability issue, there's another reason why I oppose this legislation. It's a top-down program. Now, you've heard that argument before, that and I resist that. And there are counter-arguments to that. But let me go to my number 3 reason. And that is that our state is financially fragile. Now, some will disagree with that. But in order to incorporate and bring a significant contingent liability to our state, are we financially strong enough to take care of it? Where have we been? If we look back, we had prosperous years. And then we've gone through the tough years. And right now, maybe we're in a little bit of stability. But it's very, very fragile. We have sequestration. We have an unstable federal government. We have a lot of things. We have limited savings accounts. We're in a very fragile economic environment. If I were thinking about this, I would also like to think about it as the states entering into a partnership. Now, again, we've tried to state in a small degree how this partnership would occur. But have we done a good job? I would submit that if I took the terms and conditions of this agreement to any of my attorney friends, and particularly those that I want to give me that advice, I would say that they wouldn't advise me to get into it. Number one is the partner that I'm going into partnership with isn't financially sound. All right? The partner that I'm trying to do business with is going to dictate all of the business decisions. Now, he might let me have a little say on where I go to lunch and a few minor things, but when it comes down to the major financial decisions, I won't have any say. I submit that in this partnership, I won't know all the rules. Typically, in a partnership, you try and set down the rules to begin with. And we don't have them, in spite of the 13,000 pages and the 700 additional pages and all of that. The ground rules have not been set out in good, strong financial terms. Do I have a good business plan? Have I sat down my business plan and said, this is what's going to happen in year 1, 2, 3, 4, 5? No. As a banker, this is not a good business plan. We've got the rudiments. We've even got somebody that's willing to provide the cash. But we don't have a good business plan. We don't know what it's going to cost. We don't know what we're going to charge. We're saying we're going to go into it and we're going to hope it works. The last item that I noted was, do we have the reserves? If I go into a business agreement with someone, I want to know what reserves I have in place so that if something goes wrong, I can handle it. Now, I admit the bill has tried to limit what that is, but it's only as good as the paper, and in reality, as we know, a partnership is only as good as the integrity of the partners in the partnership. And I've learned that the hard way too. And it's cost a lot of money, cost me a lot of money. The other reason I am opposed to this legislation is the right to life issues that has already been addressed. It's been indicated that there's resistance that we need to show some resistance to the applicable to this law, the bad law, in my opinion. One of the other reasons is I've thought about it as I have thought about all of the other states that have said, no, this isn't the right thing to do. And I've thought, how can we say that we know more than they know? And I'm not qualified to say that. There's 26 that have said we're going to let the federal government come in and implement it. Plus, in reality, I believe Utah has done that also. And Mr. President, if you would, I would like to read from Governor Herbert's remarks on February 6th of 2013, an address that he gave on health care reform.
Having identified the source, Senator may read.
Thank you. He's in the first part of this address, he talks about health care reform and what they have done to try and implement a state exchange. And they've worked hard at it. And Utah, and I'm going to read, Senators. Utah will work within federal law to ensure continued success of our exchange. However, there are some red lines that our state will not cross. We will not enforce the individual mandate. Even though the Supreme Court ruled the individual mandate constitutional, it is still bad policy. Each state should have the option to determine for themselves if a mandate makes sense. I do not want to be the one taking the phone calls from those individuals who receive the tax penalty by the IRS for not having insurance. We will not, number two, and I'm labeling these number two, he did not. This is the second point. Quote, we will not administer Medicaid through Utah's health exchange. We want to maintain clear separation between private insurance options in our market-based exchange and the welfare-based public programs such as Medicaid, in order to preserve the market-based principles behind Utah's unique exchange. It is critical that the exchange remain focused on the core mission of creating competition and choice in insurance markets. Those who are in need should have the opportunity to get assistance, but that determination and effort should be done separately. Number three, quote, Utah will not administer the premium tax credit through our exchange. Given the fiscal uncertainty in Washington, D.C., the premium tax credit creates a new level of entitlements for middle-class Americans. For a federal government that is already borrowing 40 cents for every dollar it spends because of entitlement programs, we cannot afford adding new entitlements. Adding new entitlements is a risky proposition, and we don't know how much this new entitlement will cost. But if history is our teacher regarding skyrocketing costs of Social Security, Medicare, and Medicaid, we're going to learn a hard lesson. For example, the original cost estimate to implement the Affordable Care Act was $900 billion. The latest estimate from CBO is now $2.7 trillion. That's a threefold increase, and implementation hasn't even begun. Mr. President, and just to continue, I'm going to just slip down closely to the end of his address and just do a couple of other things. He says, quote, the United States Department of Health and Human Services will assume responsibility for the individual exchange, including the web portal for individuals, the Navigator program, and administering tax credits. Further, because Utah is already operating a small business exchange, there is no need for HHS to duplicate our efforts. So he clearly indicates that the federal exchange is going to do those things that Utah does not feel is appropriate. One last point, Mr. President, from his address. Quote, there are many health care issues that we will need to address in the future. One area that will require attention is Medicaid. Even before the Affordable Care Act, Medicaid was a large and growing portion of Utah State's budget. In the 1990s, Medicaid consumed 9% of the state budget. Today, Medicaid comprises nearly 20% of our state budget. By fiscal year 2020, it is estimated to exceed 30%, and that is without any of the Medicaid expansion envisioned in the Affordable Care Act. We need maximum flexibility to run our program the best way we see fit. Senators, Idaho has approximately those same ratios in the costs of Medicaid and the costs of health care and where it's going. And I know that's a discussion for another day. The last reason that I oppose this legislation is I don't want Idaho to accept the moral and believed responsibility of our citizens to adopt the Affordable Health Care Act or the Not So Affordable Health Care Act. Those contingencies, those future consequences, either financial or moral, and the contingent liabilities are just too great for us, fellow citizens and fellow senators. I ask and I plead that you vote no.
For the debate, Senator Cameron.
Mr. Chairman, I want to be just brief. First of all, under Rule 39 of the Senate, I would like to disclose that I'm an insurance agent and could be perceived as potentially having a conflict.
In the Journal, Senator.
Thank you, Mr. President and Senators. I appreciate the debate that's been given here this morning and the points that have been made. I do want to touch on a couple points, and I will not try and go over everything because I think as the good lady from a good senator from 26 said in her debate, we all have our perspective, and no matter what your perspective is, it's probably right. And we're not, as the good senator from 3 said, we're not going to change anybody's mind here today. But I want to talk from my perspective, and I do want to answer a couple of the questions that have been raised, or at least try and put my perspective on the answer of those questions. First of all, I agree with the good senator from 32. We are not debating the Affordable Care Act. We are not debating those 700 pages. That would be a real easy vote. I wish they would give that authority to us. I wish we'd have that opportunity, but that's not what we have. I know there's some confusion about the cost. Both the good senator from 22 and the good senator from 3 mentioned the cost. The dilemma is not knowing how many people will participate. And the Senator Thane mentioned that a little bit in Senator from 8, and I'll talk about that here in just a second as to try and put some parameters on that. It was brought up by my good friend from 22, concerns about privacy. Let me talk about privacy just for a second. All of the provisions of this act are covered under HIPAA. All of the provisions of any application are covered under HIPAA. Currently, as the good senator from 3 knows, and the senator from 4 and I know, you fill out a 4-page application, you disclose everything in your medical history to an insurance company. Under the new program, that's not going to be the way it will be. You won't disclose any medical information. You'll disclose your name, you'll disclose your Social Security number, and if you want to apply for a tax credit, you will have to share income. Now, all of that will be, again, protected by HIPAA. Nothing in this bill or nothing in an Idaho exchange requires you or your constituents or their families to go to the exchange. That's one of the benefits of doing a state exchange is it's completely, utterly voluntary. The carriers are voluntary, those that wish to participate in it, and those that wish to purchase through it are voluntary. You've heard me say on the floor, I don't really believe I have a conflict because I believe any exchange will cause my business to lose money. I believe that a federal exchange will put my business out of business. A state exchange gives me a fighting chance because under a state exchange I have an opportunity to work with the exchange, whereas under a federal exchange, at least the way the initial act was written, and I have read most of it, but not all of it, and at least the way the initial rules were implemented, is that if you wanted to buy insurance through a federal exchange, you would go to a navigator. A navigator may not be a licensed agent. It may be somebody completely unrelated. The good senator from 7 brought up a couple of points, and I just want to touch on a couple of them. First of all, I got to reiterate again, no one is required to purchase through the exchange. You don't want to go to the exchange? Don't go to the exchange. By the way, that's the difficulty in determining the cost is we have no idea how many people will utilize it. I stand with the senator from 7 and the senator from 22 and the senator from 30 and others on trying to fight for our religious liberties and trying to protect the rights of the unborn. I feel that's very critical. I had distributed an email I received last Monday, or earlier this week on Monday, from the Catholic Charities of Idaho. And I like them, find that we are better off with a state exchange. Let me tell you why I believe that. There's no question that Idaho has done everything we can do to protect the rights of the unborn. Everybody says that. But everybody will quickly say, but that's the same whether it be a state exchange or a federal exchange. There's no question that there is controversy around abortifacients and around ELA and Plan B and whether they would be required to be covered. But everybody will quickly say both of them would be treated the same under a federal exchange and a state exchange. Here's where I think we have more at risk by going to a federal exchange when it comes to the issue of termination of a pregnancy or comes to the issue of abortifacients. Under a federal exchange, somebody once said in a previous debate that there's no way the federal government can implement 26 different exchanges in 26 different states or in all the states. That's not how this is going to work. That's not how this will be operated. The federal government is already developing their exchange, and if we don't have one, you just have a link to that exchange, and that link will be there. The good senator from 31 sent me an email a couple weeks ago that had a link to a federal exchange, and he had followed it partly way through, and so I followed it all the way through. I had my son and new grandson were looking for coverage, so I plugged their names in and their ages, and we followed it on through. By the time we got to the end, we had 2 companies. 31 plans, but 2 companies. That's the only ones they were showing. Regions Blue Shield and Pacific Source. One non-for-profit carrier, one for-profit carrier, which, by the way, is what the Federal Act says it will do. But you might be interested is along the sides, much like you would if you were on Amazon.com or any of the others, you had links that you could click that would tone down the choices, if you will. It would focus your choices. One of those links, as I recall, was pre-termination of pregnancy. One of those links was same-sex marriage. Under a federal exchange, even though the state of Idaho will have prohibited that, you will be, if your constituents will link to whatever federal exchange in whatever state it is, and then they will be able to pick and choose as they go through. They may end up with a United Healthcare or an Aetna plan or whoever else, and they're good companies. I'm not going to stand here and demean the companies. They're good companies. But they are domiciled in states that may have mandates that require coverage of certain things that we find offensive and that we find would be wrong. The Senator from 9 asked, I thought, was a really good question and part of some of the misinformation that's out there. He asked about noncompliance. The Act requires and the law requires that the exchange certify that the plans sold in the exchange meet the requirements. There's no noncompliance of individuals participating. You can choose to participate today and not tomorrow. You have that ability. There would be no non-notification of your individual constituents. It would simply be, is the carrier that's participating in the exchange offering compliant products? Is the carrier participating in the exchange playing fairly, operating fairly? There's been some question about the subsidy and the tax credits, and the senator from 7 mentioned a quote. I would just politely and gently suggest you get the whole report because the quote is sort of taken out of context, and I've seen it, and I'm not blaming the senator from 7 because frankly it's being bandied about by others who were opposed, and it refers to the standard by which they go through to determine how it would be handled. And so it points out that the first reading, one might believe, and uses the quote that the good senator from 7 used, but then later goes on to point out how the other standards, and there's this 2-step process, and how the Supreme Court has ruled based on those other standards. And its conclusion is that the Act falls under both of those standards, that there is no question that the tax credits apply to both a state exchange and a federal exchange, that there's no question that any penalties that would be imposed will not be imposed by the state exchange, but be imposed by the IRS, by the authority provided in the Act to the IRS. Now, some would argue that they don't have that appropriate authority. And I don't want to get into the weeds whether they do or they don't. I'm just pointing out for you that the same research cited on this floor as reasons not to actually, if you read the entire thing, says that you should. Now, the senator from 2, and he's left, but he talked about what are the reasons, what do we gain? I mean, he talked about a number of things, and I made a number of notes, but you know, and whether we're giving up or not. I believe we are not. I believe this is an opportunity for us to push back. I believe it is our opportunity to put our stake in the ground, draw our line in the sand, our ability to say this is how Idaho would do it. Frankly, much the same as what Utah has done in the past. Although they're now they drew the line and then they backed up and they've drawn a deeper line, but they're still doing part of that. But a wise man once said to me that diplomacy is the act of backing up while looking for a bigger stick. And perhaps in a way, that's what we're doing here, is that we're approaching this in a way that we're able to pick up a bigger stick. Here's what I think you gain with a state-based exchange. First of all, you allow a voluntary participation. All Idahoans will have the opportunity. You allow all Idaho carriers to participate. You've heard me say it before, under a federal exchange, the law says one non-for-profit, one for-profit. Now, subsequent HHS memorandums have said, we'll allow other carriers to participate, but we don't know at what the cost. Will they allow every carrier to participate? It's doubtful. In an Idaho exchange, every carrier who is licensed in Idaho, who wishes to meet Idaho law that we all pass, would be eligible to participate. One of the benefits, and we talked just briefly about it, and the senator from 8 brought it up when he talked about healthcare costs. He's right on healthcare costs. Those are some of the things that we need to do. But let me tell you how the exchange, if this wasn't tied to the Affordable Care Act, we'd be having a debate about how the exchange actually can help employers save money and how the exchange can actually help people make appropriate decisions with their health care dollars. That's one of the major benefits. This was, frankly, a Republican idea endorsed by the Heritage Foundation, endorsed by ALEC, until it got tied in as part of the Affordable Care Act. To my friend from 3, I thought you looked pretty good, actually. And even in gray, I didn't notice that it was gray, but I thought you looked good. And I know that this is tough. And you and I look at it differently, but we have the same perspective. I frankly don't fault the companies for trying to build up reserves, knowing that the Affordable Care Act's implementation is coming forward. And knowing that from once that's fully implemented, the choices that they have to make become much more restrictive. And knowing that if we defaulted to a federal exchange, perhaps we wouldn't have built up the reserves quite as much had we made the choice a year ago or so to go to a state-based exchange. But knowing that we may default to a federal exchange, they got to have some mechanism. If they have to show that they're the biggest dog in town, they got to be able to show that. They got to show that they got the most customers, the most reserves, etc., in order for them to play in that federal exchange. I don't fault them for that. The senator from 18 talked about consumer protections. I want to promise you, senator from 18, that the consumer is much better protected under a state-based exchange than a federal exchange. That the consumer has a seat at the table, an Idaho consumer, not a consumer from New Jersey or Wisconsin or Massachusetts, but an Idaho consumer has a much better seat at the table. And I want to commit to you that I believe that the fees charged inside the exchange, there's a direct incentive for them to be pushed down. The dilemma is, as mentioned with the Senator from 28, we can all guess as to, he's got his theory as to how many people will participate. I can tell you in the high-risk pool, which is largely guarded as one of the most successful pools in the nation, after 10 years, we're barely hitting 10,000 participants. That's not total enrollment. That's participants ever. So some would come in, left. So we have no idea. That may be, and initially, people may not choose to go there. Frankly, I hope they don't. I hope they come, and talk to their local agent. But they could, and they may find it as a useful tool. I think there's an incentive in the program in order to help hold the cost down. Now, lastly, the senator from 30 talked about the comment made by the state treasurer. I want to thank him for debating as long as he did, because it allowed us to check that. So, and in conversation with the state treasurer, I'm told that he said that the Moody's said it was just a routine inquiry, that there was nothing negative, nothing more to it than that there's no contingent liability. And frankly, I can see the argument, but I could also argue that there's a potential contingent liability and a contingent loss of revenue to the state as businesses are hurt under a federal exchange versus a state exchange. But I'm told that and frankly, Moody's has given us the highest rating, as has Fitch's, as has Standard & Poor's. I've had the opportunity to be on some of those discussions with them. The Senator from 30 also talked about the 26 other states. I had handed out a map, and it has on one page, and some of you have it double printed, and I'm sorry for that. It shows my inadequacy in running a copy machine instead of handing somebody else. But the first page of that shows how many states are doing state-based exchanges and how many of them are doing partnerships and how many are doing federal. Do you want to guess how many of those states are in communication with Health and Human Services, even those that have said they're going to a federal? The answer is all of them. Do you want to guess how many of them are still talking about, behind the scenes, doing a state-based exchange? The answer is all of them. Many of the other states have chosen, and I don't want to imply their motives necessarily as to why they've chosen to go the federal route, but the reason for the page 2 is to show how many of the states are also looking at expanding Medicaid. It's rather interesting to see a state saying no to exchange, and then on the other hand saying yes to taking Medicaid. Out of the 26, I think there's something like 8 or 9 that are saying yes to Medicaid. Many of those states, by the way, that are saying no are doing so. They were never part of the original lawsuit. There's actually another graph that shows which ones were participants, as Idaho was in the lawsuit, and most of those states weren't. I do want to touch on, and I mentioned before, the issue of mandates, and that's part of the reason. You might be surprised to know that every single state of those 26 states, their costs are higher than Idaho's. Every single one of them. Every single one of them have higher mandates, and they cover a wider range of products and services. Every single one of them have more mandates. Most of them at least twice as many, some 3 times, pushing 4 times as many mandates. We have a total of 7 mandates in our state. Most of the other states have at least 14 to 25 mandates. Mr. President and Senators, I, like most of you, don't believe the vote's going to change necessarily that much, but I'd urge you, this is a step forward to, it's not just words on a paper. This is a step forward to protect Idaho citizens, Idaho consumers, to protect Idaho jobs, to protect our rights as Idaho citizens so that we don't acquiesce to the federal government and allow them to come in and run it the way they would without our input. Thank you, Mr. President.
For the debate, Senator Johnson.
Mr. President, thank you. Would the good senator from District 27 yield to a question?
Senator Cameron, would you yield to an inquiry?
Certainly.
Thank you, Mr. President. Good senator. I just want to understand the navigator position clearly because I think that's a very important one. My understanding is that a state health exchange would have a navigator. Is that correct?
Senator Cameron.
Mr. President, and good senator from 7? 6. That is correct. Under the Federal Act, we are required under a state-based exchange to have a navigator. What isn't defined is what defines what a navigator is. And so we have the opportunity to define what the responsibilities a navigator might meet. Are they licensed? Do they have airs and emissions insurance? Are they trained, etc.? So that's a benefit from the state perspective of a navigator versus a federal perspective. We would not have that input. They could pick a call center in Wichita, Kansas, to be their navigator.
For the debate.
Thank you,
Mr. President.
Senator Bayer.
Thank you, Mr. President, to debate the bill. Thank you, good senators. I do recognize the seriousness of the issue, and I don't want to, I'll try very hard not to repeat anything, but I do have to find a little comical irony in some of this, and I am a big fan of British humor. And I was at home with my wife talking about how we got where we are today and how that was discussed in the previous debate on 1042, and there's been talk about from proponents defensively about Trojan horse analogies, and so I was talking to my wife about an analogy between the Senate sending the House a giant wooden rabbit and the House sending back a giant wooden badger, and that might be lost on some of you, but I told her in regards to the Trojan horse analogy, even though she meant it in a strictly military term, I said that's really not accurate because it has a bumper sticker on it that says what it is. And so I don't believe that any of my good colleagues here view it in that way, and I think that we are going into this for the greatest part knowingly. And I appreciate the good senators from 27's comments, and I have, quite frankly, a hard time agreeing with any of them. I think that the guise of preserving options, oversight, and accountability for our citizens is just that. I don't think this language accomplishes any of that. I previously mentioned how I thought that it was in self-conflict with its claims, the beginning of the language, and then the subsequent empowerment of this body politic, this quasi-governmental entity. I would say, with all due respect, that's somewhat analogous to someone coming up to you in an alley with a name tag that expresses a certain platform, a certain moral character, and then proceeding to mug you. That's unexpected, and I think that's what this language, whether it's intentional or not, provides for. That's where it lends me a lot of concern, because I do believe that ultimately this is more captive than protective. And it almost seems like it's, in my opinion, unwittingly subservient to the federal provisions. That lends me a lot of concern. An exchange is not an exchange is not an exchange. Historically, some of the talk of exchanges have been oranges and apples. As per some of the literature from the proponents, that's a debate of yesteryear. That's a free market exchange. This is black and white under this requirement. We're having this debate this session because of federal action. This is not a free market debate. It was not a free market debate in 2011 on the floor, when many in this body supported going down this road, and I will note, far prior to the Supreme Court ruling, far prior to the last general election. So let's be as transparent as possible as to how we got where we are, dispositions over the last few years, and this debate on this bill today. If this debate
Mr.
were
President,
about...
I apologize. I ask unanimous consent. Go at ease.
Objection, Senate be at ease. 13th order of business. Senator Bayer was debating. Senator Bayer.
Thank you, Mr. President. Thank you, good senators. Just a few more points, if I may. I believe another depiction of what we're doing is actually handing the keys to our constituents' homes over to the federal government. The mention of oversight and authority in the Idaho way, if that were the case, in my personal opinion, we would meet those concerns here and now. But one of the challenges with this language is that you must comply. And, Mr. President, I know that it has been mentioned in debate today, but I will mention very briefly again that the powers and limitations stated in this language tie the hands of the exchange in such a fashion that the exchange shall not prohibit any health carrier or their plans from participating as long as they meet all requirements of applicable law and requirements of the exchange consistent with this chapter. That doesn't say applicable law version 1.2. It doesn't say this act of this time. It's in perpetuity. And now you're codifying that default. And I think that that's a very, very important point and a dangerous part of this language with unintended consequences. I wonder what this debate would be like if we were talking about another current hot topic in federal agenda in regards to Second Amendment rights. It's not far-fetched to envision a scenario where those are grossly differently interpreted and possibly held up by court, and then come to states like Idaho saying you have a choice of how to enforce, kindly with your own enforcement, or we will do it for you. I wonder how that debate would be. Actually, it's funny that in that whole subject matter, and I think there is a common nexus here because it's the same current federal administration, I think that in that instance, we take a lot of preemptive measures to protect, whether they are in federal compliance or not. I've also heard that the good sponsor said that, I believe it was stated fairly as a matter of opinion in opening, that clearly a state exchange is best to protect from a single-payer system, so I cannot choose a federal exchange. It's very interesting that there are those here that in previous debates said, I support a single-payer system, I support this measure, I support this bill. I find that rather fascinating. Which avenue is truly the avenue of the federal agenda? And there are those, with all due respect, I was very respectful in my previous debate, to agree to disagree with the current federal law and federal agenda, and those who support it, who openly endorse and encourage and support it. That is their prerogative, that is their opinion, that's their stance, and I respect that. I think this is an avenue towards that. I cannot stand here and say otherwise. And I think it's very important for us to take all of those factors into consideration. I know that this is a bit belabored. I appreciate having the opportunity to express this disposition, although I'm not sure if I appreciate it as much as the first time. But I guess we'll just move on with the foregone conclusion, and with that, Mr. President, I will be voting no. Thank you.
For the debate, Senator Pierce, for what reason do you rise?
To debate the bill.
You have
Mr. President.
floor, Senator.
You know, fellow senators, I want to be known that I respect every one of your attitudes, and I don't know that we've ever seen had a subject before us that there was really so little known about, but so much known about that we're not sure is even right. You know, as it's progressed and time has gone on, we've seen more and more. I'd like to just talk about a couple things and sit down here in a minute, but I just earlier did a little research on Utah's exchange. They, in November, the latest information is out on them. They have 313 employer groups with 2,579 people in with 4,850 dependents for a total of 7,429 people on their exchange. Their broker commissions are $37 a month per person. Their administrative fee is $8. Utah has 2.9 million people. They're nearly double our size. I think that sometimes we hope the costs, and as that said, we hope, we don't know, and we're not sure. You know, Mr. President, may I read from Forbes?
Having identified the source, Senator may read.
I want you to think about this because I think this again points out the very fact that we're going into the unknown, what we're not sure of. Last month, the CEO of the nation's largest health insurance company warned that he and his peers may balk at participating in Obamacare's insurance exchanges, online government-run portals, where consumers and small businesses without conventional employer-sponsored coverage may shop for the policies starting next year. We will only participate in exchanges that we assess to be fair, commercially sustainable, and provide a reasonable return on the capital they will require, Stephen Hensley said. That's ominous news for Obamacare. If insurers don't participate in the law's exchanges, then consumers who had hoped to secure affordable coverage through the new marketplace will instead find few choices and high prices. Taxpayers could be hit hard too, as higher premiums in the exchanges will require more public spending on subsidies. And then skipping down on the article just a little further, I'll share this next little bit with you. Last month, the Department of Health and Human Services stopped using the word exchanges in press materials and online websites and started calling them marketplaces. As Gene Clancy, the Director of Healthcare Policy at Freedom Works, observed, if they're trying to relabel, it means they're flailing. When Vice President Joe Biden was asked before Obamacare became law whether insurance companies would go along with the president's heavy-handed intervention in their business, he was blunt. You know we're going to control the insurance companies, he told ABC News. Maybe not. If insurers opt not to participate in Obamacare's exchanges, the feds will lose control of their health care effort, saddling consumers and taxpayers with higher costs. We are all going into an area that we don't know too much about. You know, we've heard about flexibility. And again, I quote out of the PPACA Act itself, Section 1311. A state insurance exchange may not establish rules that conflict or prevent the application of regulations promulgated by the Secretary of HHS. So the idea of flexibility in our exchange, I don't really think is there. It's a hope. It's a good hope. I hope we have flexibility. But the law tells us we won't have. You know, as I've thought about this, and everybody looks for an analogy, 20 years ago, a family in my area came and asked if I'd visit with their daughter. She was engaged to be married. And in that engagement, they saw some things, as well as some of her friends had seen some things that didn't look good in that expected marriage. And so they said, will you talk to her? Not knowing what to say, I encouraged her to simply wait, extend the engagement period, look ahead, and just give it some time. She elected not to wait. She moved ahead. 20 years later, she came home a severely damaged woman. She had been involved for 20 years in a terribly sad marriage, one controlling, one where there was severe domestic abuse. Should have been the 20th happiest years of her life, turned out to be the direct opposite. If she would only waited, she eventually would have seen the same signs. I think in our assessment here today, maybe that's good advice again. You know, House Bill 248 is our ticket to the ball, but we're going to get to pick up the tab for it. It's going to cost us. I don't see the imaginary table. I don't see the chair. when I realize that we have to comply in every aspect with what the federal government dictates, I don't see the flexibility. I don't see the chair where we get to sit down and say, let's have a family council and decide what we're going to do. You know, the dates we've said, I look back and reflect and think, you know, this wedding that we're talking about was first told that November the 16th was the deadline. And then for some reason, the federal government moved it to December the 14th. And now they moved it to February the 15th. And we are now at March 21st, and we still haven't gone through the wedding, and we don't know what the next deadline is. They want us to do this so bad for them, it just looks to me like a trap. Why would you keep extending that date to get involved? Why would you keep pushing that out? Because you don't want to do it yourself, you want them to do it, and we're the them, and we really shouldn't probably be doing that. You know, I think there's some other issues that are deeply concerning here, and some of those are, I think, the entitlements tied to this. We see our neighboring state, Utah, who has resisted and who has said, no, we will not put these tax credits and these subsidies through our exchange. They're wrong. We look at the federal programs. If you want to see cities that have had 3 and 4 generations of federal programs, drive through Detroit, Chicago, New York, and look what subsidies and federal programs have done for those families, and they haven't helped them. They have not moved it back. We ask what the real motives are. What are the real motives of what we're kind of pushing here? And I know I'm talking about two different things here, both 248 and the federal law, but it's control. It's really control. And we don't really have to do that. You know, our friends too have counseled us to wait. Our friends too have pled with us. Our friends like the Cato. I came here 12 years ago. I didn't know who Cato was, but I've heard him quoted many times in both these bodies. Goldwater Institute, the Heritage Foundation, Freedom Foundation, Farm Bureau, the Republican Party. Many of our friends have said, let's just wait. Let's just hold up. Let's get more information. Let's see what other people go through before we tie into this. You know, we're told we can get out, that we can get a divorce. But somehow we've never got divorced from Medicaid, from food stamps. We can't even get away from EPA. It's not getting better, it's getting worse. You know, I have a quote by Patrick Henry that I think is very telling. And I think we ought to consider it in all that we do. He says, oh, excuse me, Mr. President, may I read? It's a quote from Patrick Henry. Always. The Constitution is not an instrument for the government to restrain the people. It is an instrument for the people to restrain the government, lest it come to dominate our lives and our interests. That's what's happening here. And we hear talk about, well, this is unconstitutional. Well, now hold it. Who's it unconstitutional, for us or for them? You know, the good gentleman, senator from 2, gave a debate, and as he sat there, I thought, you know, I remember a certain Idaho governor who parked a railroad car, or a police car on a railroad track in defiance of the federal government. And I'll bet there's not one of you here that would stand and tell me that he did wrong. He was a hero for it because he stood up against something that was wrong, something that we asked not to do to the state. And he said, you won't do it. And he parked that police car on that track, ordered it done, and then stood his ground. I think we have great examples of great people in our heritage, in our lives, that have said, no, this isn't the time and place. And I hope that we'll respond and listen, and that we'll vote no on this bill. Thank you.
The debate. Senator Hageman.
Thank you, Mr. Chairman. Mr. President, I'm going to try and keep this short. I don't want to contribute to what I hope will not end up being a record-setting day of debate. So we'll try and keep this short. I think one of the things that we need to recognize, all of us need to recognize, is the passion behind our decisions. Maybe some votes will be changed, maybe they won't. But I think from our core, all of us are trying to be protective of Idaho and our citizens. I see the trembling hands and the trembling lips and the passion of people debating on where they stand, and it gives me a great deal of pride to stand among all of you, because we're all trying to do the right things. We're trying to make the right decision. I think one of the things that the good gentleman from 2 said that I think is very poignant. The only snake I like is a dead snake with some barbecue sauce on it. And so I appreciate what the good gentleman said about growing up with snakes. But he had a tool that he used to keep the snakes out of the house. If we vote no on this bill, we lose our tool. We've heard a lot of discussion about trailer bills, but we haven't seen any. I don't know what I would write. If I were to vote no, I would want to have my next step. I would want to have a trailer bill or some kind of a bill here that I could depend on to go after. I don't know what that is. I voted yes a couple of years ago on a bill that said we're going to sue the federal government. That was our first step. This is our second step. We have a tool. We're going to do our best to keep the snakes out of the yard. I don't know what our third step is, but I got a shovel I can swing. And until I can come up with a third step, that's all I can use. I appreciate the passion, and I pray that all of us, after this is over, are going to be just as close and friends as we started out here in January. This has been probably one of the most divisive issues that I've seen in my time here. And it hurts to see friends working against one another. So I will, my vote will remain the same. And again, I hope we can continue on and not set any records today for debate. Thank you.
For the debate, Senator Getty.
Mr. President, I would like to also disclose that, subject to Rule 39H, I do have a health insurance license. However, I've not derived income from that for almost 2 years.
Be recorded in journal.
Thank you. Senators, I agree with the senator from 3 and 27. We're not changing votes here. And I also agree with the senator from 14. It's time to try to wrap this up. It's about this hour in the debate in the body on the other side when a member of that body got up, and I'll paraphrase it, suggested that we quit wasting air and vote. I suggest that would be appropriate here too.
For the debate, does any senator wish to debate for the first time? Senator Nuxels recognized to debate for the second time.
Thank you, Mr. President. This will only take a minute. But this is concerning the handouts, and if I may read an email from a constituent that was just sent to me.
Having identified the source, kind of, the senator may.
Okay. Okay. The Catholic Church of Idaho's political policy statement concerning the state exchange is what our faith terms a prudential judgment. Because it is a matter of prudential judgment, a Catholic in good standing, including a Catholic politician, can be of a different opinion. Now, if it were a matter of faith or morals, as a good Catholic, I and others ought not disagree, but this is not the case here. So to reiterate, a pro or con stance on the state exchange from the perspective of the Catholic faith is a matter of prudential judgment, and good Catholics can disagree on this point. But I must say that I find it quite audacious that those not belonging to a faith would pass around a political position statement of that faith while at the same time not understanding the nuances of that faith because they do not belong to it. That's it. Thank you, Mr. President.
For the debate, Senator Winder.
Thank you, Mr. President. Just quickly, again, thank everyone for your debate, the passion that
lingers here today from our previous debate. I too believe that we're probably not going to change anyone's vote or mind in this process, and I honor each of your positions. But I would be remiss if I didn't stand up and briefly make a comment that I don't think there's enough difference in 248 that I can support it. My major concerns with it, we still do not have protection for a right of conscience law in Idaho. We don't have protection for religious freedom, which is guaranteed by our Constitution and both state and national, and it doesn't provide the protection for the unborn that I would like to see, and we don't have a trailer bill, and I'm very troubled by that. I'm also troubled that we don't know the cost. We go back and forth almost daily in committees and on the floor about fiscal costs and the implications of that. And I think that there was a wise person years ago, and some of us look at him differently than others, but he said, if you're going to build a tower, you need to sit down and calculate the cost. It doesn't end there. He goes on to say, if you start that tower and only complete the foundation, when people go by and see it, they're going to ridicule you because you didn't finish it. I don't know that we're going to finish this with what we're starting. My fear is that the federal government has this as one of its highest priorities to get this in place, even though we all know that there's, I think, a huge financial crisis not too far around the corner when people start or stop lending us money. And when that happens, I think that we will indeed be ridiculed for laying this foundation. Thank you, Mr. President.
For the debate.
Mr. President.
Senator Baer.
For a second time.
Does any senator wish to debate for the first time? Senator Baer is recognized to debate for the second time.
Thank you, Mr. President. Thank you, good senators. Very briefly, the term in debate from the good gentleman from 27 was used to acquiesce, which is defined as to accept, comply, or submit passively, to submit silently or without protest. I agree with the term. I agree with a different application. I believe that that's what this language is doing. Mr. President, in closing of my debate, I would like permission to read an excerpt from a letter dated January 30th, 2013, from the Department of Health and Human Services from the Regional 10 Director, Susan Johnson.
Having identified the source, the senator may read.
Thank you, Mr. President. Thank you, good senators. Dear Senator Baer, in the coming months, we will be focused on the successful implementation of the Affordable Care Act, and more specifically, the new coverage opportunities available for over 28 million Americans through an expansion of Medicaid and the creation of the new health care marketplaces in each of the states. I am hopeful that we can work together to help make the promise of this law a reality for your constituents. Mr. President, good senators, that doesn't sound to me like a federal government disposition of do this or we will come in and do it for you. That sounds more to me like why don't we join hands and do this together? Thank you, Mr. President.
For the debate. No, Senator Hill.
Thank you, Mr. President. It's been a difficult issue, I think, for all of us. But I don't think this is a matter of good guys and bad guys. Those opposing this bill do not hate Obamacare any more than the rest of us, at least in the majority party. They don't value state sovereignty any more than I do. One side is not more patriotic or freedom-loving or conservative than the other. We all care about this state. We want the very best for our friends, for our families, for our neighbors, and for ourselves. Let's be honest with ourselves, too. If this bill we have before us were to establish a federal exchange, if that's what we're voting for here today, I wonder how many of us would be supporting it. Does anyone really believe that an exchange run by the federal government will give us more flexibility? That it will be less expensive? That it will be more efficient? Or that it will be better for Idahoans than an exchange run by Idahoans, even with restrictions? So the real issue here is not whether a state-based or a federal exchange is better. I think it's about what effect the passage or rejection of this bill is going to have on the future of Obamacare. All of us in the majority here oppose Obamacare. After all, we were among the first who sued to prove that it was unconstitutional. Most of us worked really hard to change the presidency and the Congress in hopes that it would get repealed. We've all been on the same side, and we still are. No one here has sold out to any special interest anywhere along the line for any purpose at any time. If anyone believes that, then they don't know the caliber of the men and women in this chamber. These are honest, sincere people, but different human beings sometimes see things differently. I've quoted him before because he's worth quoting. As Thomas Jefferson said, every difference of opinion is not a difference of principle. Every difference of opinion is not a difference of principle. Now, if we really believe, and there are some who do believe this, if we really believe that if enough states refuse to set up a state-run exchange, that Obamacare will eventually go away. If you believe that the federal government doesn't have the resources or the horsepower or the will to set up a federal exchange in every state, if you really believe that if Idaho rejects this bill that Obamacare will fail, then you have to reject this bill. You have to vote against it. If you really believe that a vote against the state-run exchange is an invitation to the feds to come in and take over our health care system and set up their one-size-fits-all program, leaving us watching from the sidelines, if you believe that defaulting to the federal government places us directly into the hands of those in Washington who wanted a federally run health care system all along, if you believe that the resulting federal exchange will be more expensive, less effective, less responsive to our citizens, and result in more federal control, then you have to vote for it. It's all in how we see the future playing out. There aren't any good guys or bad guys in this. As the senator from 14 said, we all love our country and our state. We all revere our Constitution. We all seek to defend freedom and choice and accountability. We all want to do the right thing. Many will criticize your choice here today, either way you vote, because the choices we have stink. But the critics are wrong if they question what's in your heart. And I thank you for what I see in your hearts. I'm proud to be with you. Thank you, my fellow senators and colleagues.
For the debate. Senator Thane, for what reason do you rise?
Debate for the second time.
Does any senator wish to debate for the first time? Senator Thane will be recognized to debate for the second time.
Thank you, Mr. President. You're all ready to leave, but something that the good gentleman, senator from 34, prompted me to get up. I really do believe that a federal exchange would be better, because we do need a common opponent. It's been said that an exchange is voluntary. We don't have to go to the exchange, which is true, we don't. No one has to use the exchange. The only reason you have to go to the exchange is if you want the subsidy. The Medicaid, people that can qualify for Medicaid can go qualify for Medicaid as they do now. They can sign up at the local office. People that want health insurance can get health insurance with private insurers. We really would be better off having a federal exchange, because then we could work as a state to make sure that none of our citizens needed to go there. So I think not having a state exchange is the way to go. Therefore, we could work to not go to the federal exchange. We don't have to go to the federal exchange. We don't have to go to the state exchange. Well, one last point. Senator from 27 pointed out this is voluntary. Actually, there's two sides of the voluntary coin. You don't have to go to the exchange, but we're not being relieved from the tax burden of participating. So it's a little bit difficult not to participate when we're paying for it, but we can't get the benefit unless we go to the exchange. So to say that it's voluntary is partially true and partially not true. Thank you, Mr. President.
For the debate. Hearing no further debate, Senator Tippett is recognized to close debate.
Thank you, Mr. President. Well, Senators, there have been lots of differing opinions expressed, but I think the one thing that most of us could agree on is that this has been a frustrating process. And if you don't mind, I'm going to keep my closing debate brief. First of all, I want to say to the opponents of this bill, thank you for not making an attempt to send this to the amending order. Frankly, I anticipated that would happen. We discussed last time we debated this bill why some of us feel like that isn't the place to make changes. So I just want you to know I appreciate that. Before closing debate, Senators, there's one issue that I want to discuss briefly. At least one opponent of this legislation, not a member of this body, has suggested that I personally have a conflict of interest because I serve on the board of the Idaho Association of Commerce and Industry. I have represented my employer on that board since before I was appointed a senator, and I'm one of about 40 members of that board. It's a very large board. I also serve on other boards, including the board of my local hospital, a county hospital, nonprofit, Bear Lake Memorial Hospital. I've not declared a conflict of interest because I did not believe that one existed. I checked with the Attorney General's office some time ago just to make sure I was correct, and they confirmed that no conflict exists. Let me assure you, Senators, my constituents, and the public at large, that as a state senator, I represent my constituents, and I vote in the interests of my constituents and no one else. Now, Senators, I'm saddened by how this issue has divided the body. I want all of you to know I respect your opinion. I sincerely do. My heart is with you. I wish we could keep the Affordable Care Act from being enacted. I don't see any way. And much of the debate since its beginning on this issue has centered around the question of whether or not the federal government would follow through with the mandate to create a federal exchange for the state of Idaho if we don't create a state exchange. I think many opponents now are admitting that that will happen, or it's likely to happen. I think some still hold on to the hope that that won't happen. Mr. President, may I read from an email that I received from Tammy Perkins dated March 15, 2013, and it involves an Idaho conservative blogger is the name, doing an interview with the gentleman on the second floor on March 12th.
Having identified the source, the senator may read.
Thank you, Mr. President. Senators, in this email I have a transcript, as I just mentioned, of a conversation that the blogger did with the gentleman on the second floor just recently. And the gentleman on the second floor said that he was just recently in the White House with 48 other governors and the president and others. He asked Kathleen Sebelius, "Are you going to have this ready by January 1st? Of course, speaking of the Affordable Care Act and the exchanges, she said, "We're pulling out all the stops. There are other things that are going to go wanting, but this is the president's legacy." She made it very clear. Other things might be put on the back burner, but not this one. Incidentally, the gentleman on the second floor added, "I think it's a bad legacy, and I think it's a bad way to go for the nation, but I just can't walk away from the table without insisting on trying to get some things in there that reflect the virtues of and the morality of Idaho." Senators, I'm sympathetic to the issues around requiring coverage for contraceptives. I really wish we could do something about that. I've heard that there were promises of a trailer bill. I wasn't aware of that. I certainly didn't make any promises. The fact is we can't address that without defaulting to a federal exchange. If that's included in our legislation, our plan will not be approved and we will end up with a federal exchange. And the plans offered under the federal exchange will include coverage for contraceptives. Again, that's a battle that has to be waged at the federal level. And Mr. President, I would like to ask approval to read from an email that's an email from Paul Diaguardi, Director of the Office of Intergovernmental and External Affairs, U.S. Department of Health and Human Services, to Mr. David Hensley, and it is dated March 20th.
Having identified the source, the senator may read.
Thank you, Mr. President. The office of the gentleman on the second floor has inquired of Health and Human Services about the potential to put some protection that would not require coverage of contraceptives in our law. They told me it's difficult often to get a response from those folks. A response finally came yesterday. I received it just this morning. Excuse me. So Mr. Diaguardi, again, his title is Director, Office of Intergovernmental and External Affairs for HHS, said this: "David, in response to your questions, I offer the following information. Federal law requires that a certified exchange may not make available any health plan that is not a qualified health plan. As outlined in the statute, qualified health plans must provide all of the essential health benefits, including contraception. If the Idaho Exchange is unwilling or unable to certify qualified health plans that meet that requirement and enable the purchase of qualified health plans, including all the essential health benefits, it would not be able to receive final certification from the U.S. Department of Health and Human Services to operate a state-based exchange." Now, here's the part that I really want you to pay attention to. Without a certified state-based exchange in place in Idaho, a federally facilitated exchange will be operational in Idaho in time for open enrollment on October 1st, 2013. Senators, that's not the news we wanted to hear. Not the news that many of you wanted to hear. It's certainly not the news that I wanted to hear. But there we have it, from the source, from the authority, that we would default to a federal exchange, and it would be operational on October 1st, and it would include those provisions that we don't want in our law. Senators, if I knew a way to get out of having a health care exchange under the provisions of the Affordable Care Act, I would do it, as would nearly all of you. I'd do it in a heartbeat. Fact of the matter is, after having studied this issue for way too many hours, after having talked to many people about the issues, I can find no way out. Opponents of this legislation cannot tell me how we get out of having an exchange. Some believe, as I've already discussed, that the federal government will never implement a federal exchange in Idaho. I think those numbers are diminishing. Some still hold on to that hope. I wish I could believe that, but I can't. All the evidence indicates to me there's no question they will impose a federal exchange on Idaho. Others have told us that the federal exchange will collapse due to lack of resources. If it does, we'll discontinue our state exchange, but I can't believe that's going to happen. As Director Sebelius has indicated, this is the President's legacy. He's not about to let it fail. Others believe we can simply say no and refuse any kind of an exchange. We can say no. We can say it all we want, and the federal government will simply come in and impose a federal exchange. So which is better, a federal exchange or a state exchange? That's what we've debated here today, and Senators, thank you for an informed and respectful debate. I believe there are significant benefits to doing what we can to maintain what little control we can, and operating a system that is somewhat unique and separate from the federal system. I believe that will make it more difficult for the federal government to move to a single-payer health care system. Senators, I invite you to vote in favor of House Bill 248. I believe that it's a vote for Idaho. Mr. President, thank you, and with that, debate is closed.
Debate being closed. The question is, shall House Bill 248 pass the Senate? Secretary will call the roll.
Baer. Bayer. Bach. Brackett. Buckner-Webb. Cameron. Davis. Durst. Fulcher. Getty. Guthrie. Hagedorn. Hyder. Hill. Johnson. Keogh. Lacey. Lakey. Lodge. Martin. Mortimer. Nonini.
Mr. President.
You debated, Senator. You don't have 60 seconds to explain your vote.
I wanted to disclose pursuant to Rule 39. May I?
You're supposed to declare earlier. How does the Senator wish to vote? Senator Nonini will be recorded as voting no.
Nuxel. Patrick. Pierce. Rice. Sidaway. Stennett. Thane. Tippett. Fick. Work. Winder. Johnson.
Mr. President, 60 seconds.
Senator Johnson, you have 60 seconds.
Thank you, Mr. President. Good senators, I do thank you too for the debate. It's been very interesting. And I guess after listening to this in the previous debate, it seems to be really a discussion about commerce and negotiation. I don't think it's so much about healing and medicine. And so, when I break it down like that and I think about future options to this debate, I've entertained the thought about could we pass additional legislation that would allow us to make future changes to address navigator issues and things like that. And I think under both exchanges, the core functions are going to be basically identical. And if you go to healthexchange.idaho.org and you look at that, they have a copy of that caduceus, which is that double entwined serpent. And I think that's right.
How do you like to be recorded, Senator?
Senator votes no. Thank you.
Lacey. Patrick. Work.
Second call.
There is also a pair vote, Senator Schmidt voting aye and Senator McKenzie voting nay.
Roll call shows 23 ayes, 12 nays, no absence excused, majority have voted affirmative. House Bill 248 is passed the Senate. The correction title, hearing none, title is approved. House Bill 248 will be transmitted to the House. Senate now is for final consideration. Senator Davis.
Mr. President, personal privilege, if I may.
You have the floor.
I'm kind of embarrassed, Senators. I haven't planned past this moment today. And so we're going to go at ease for just a minute. I didn't know for sure how things would work, so I need to just have a couple of minutes of downtime to visit with our chairs for this afternoon and report back to you. So if you'd be patient with me for just a couple of minutes, I ask unanimous consent the Senate go to ease, subject to call the chair.
Without objection, Senator B. Davis.
Welcome to Idaho in Session, Legislature Live, the Senate channel. Idaho in Session is sponsored by the Idaho State Broadcasters Association, the J.A. and Catherine Albertson Foundation, Union Pacific Foundation, Idaho Association of Counties, Idaho Cable Telecommunications Association, Association of Idaho Cities, and your contributions to the Idaho Public Television Endowment.
and Tuesday. Senate will come to order. Prior to going to ease, the Senate was the 13th order of business. The Senate's at the 13th order of business.
Mr. President.
Senator Davis.
If I might have an inquiry of the President on a rule, I know that you have previously ruled that possession of consumables is not a problem. I have also heard you say that consumption is a problem. But is the act of consumption that's against the rule, the moment that you put it into your mouth, is that what is prohibited? Or if I put it into my mouth prior to coming onto the floor of the Senate, am I allowed to continue chewing it?
It depends upon whether your mouth is facing the majority leader or the president.
Mr. President, I ask unanimous consent the bills in the 13th order be reordered as follows. Placing Senate bills at the top. Excuse me. Placing Senate bills at the top, followed by House bills as amended in the Senate, if any, followed by Senate bills from the Finance Committee, followed by House bills that are not from the Appropriation Committee, followed by House bills.
Got that? Okay. Hearing no objections, so ordered.
Mr. President, I ask unanimous consent to send advance to the 15th order of business.
Objection to send advance to 15th order of business. Senate's at the 15th order of business. Miscellaneous business and adjournment. Senator Davis.
Personal privilege, if
you
I
have
may.
the floor.
Mr. President, Senators, we are going to adjourn until 9:30 a.m. tomorrow. We're going to have a lot of, we may have a lot of administrative work that we need to do. And so to our afternoon committees, if it is possible, before you leave today, if we can get the committee reports up, that will help us move things around tomorrow. But if you have a 1:30 committee meeting today, that is now going to be held from 2 o'clock to adjournment or 2:30, whichever occurs first. So 1:30 will start at 2 and go to 3:30. I apologize, I misspoke. It will go for an hour and a half, from 2 to 3:30. Senator, the chairman of the Commerce Committee about had a heart attack. I apologize. The 3 o'clock committees will meet at 3:30. And they will also go until adjournment. I've stopped trying long ago to put an end time otherwise there. So that's, and you'll meet in your normal rooms is my understanding. Prior to adjournment, I ask if there are introductions or announcements.
Announcements. Senator Vick.
Thank you, Mr. President. In a bit of irony, I would just note that today was the day that the House of Representatives passed the Affordable Care Act and sent it to President Obama for his signature.
That is a bit ironic. Further announcements. Senator Davis.
Mr. President, I move that the Senate adjourn till the hour of 9:30 a.m. tomorrow.
Senator Stinnett.
Mr. President, second the motion.
Moved and second, the Senate adjourn till 9:30 tomorrow. All in favor say aye. All opposed nay. The ayes have it. We are adjourned.